Good morning, good morning, good morning, Lawnerd. And if you are replay crew, good afternoon, good evening, good night, whatever day it is, whatever time it is, it's good to see you. Replay crew, remember everything is timestamped down below. And if you want to be part of the live crew and you're like, I can never get it to, what time are we live? Because it does change sometimes. And sometimes it's more of a we are live-ish. Well, the Lawnerd app is for you. Get the Lawnerd app at lawnerdapp.com. It is free on iOS and Android. And it will let you know when we're getting started and what we're covering, and if there's any wild moments that we need to talk about. So today, we have a lot on the docket because it is food court. We have not done food court in a minute. We need to take a look at what is going on. Somebody's got a death wish. That wasn't just a headline. Trader Joe's is getting sued. We have a follow-up on that Reese's case that we covered from the peanut butter cups. We've got a little bit of spooky season theme happening. Thank you all. We are ready. One of the Law Nerds sent a cousin to Vincent Van Ghoul. So we have Halloween, Vincent Van Ghoul. Halloween Vincent. Who said Vincent Van Ghoul? Felicia in the chat said Van Ghoul. Yes. Vincent Van Ghoul, not Vincent Van Gogh. That was 10 out of 10. Yes. We have our Halloween goat. We have our Halloween goat. And yes, I was supposed to light up this hat, but the batteries died when I turned it on, and I didn't want to be any later for court. I didn't for court for Law Nerd court. I did not want to keep delaying us. So I was like, hey, that's a problem. So I didn't refresh the batteries. We'll see if we get it done before tomorrow. We will see. I'm going to try to do that. But today, as I said, we have food court. But Law Nerds, we're going to roll the intro, and then we need to have a little bit of a chat because I need to ask you something. We're going to let the chat, if you are live now, because you have the app and you got live, when I got live, if you're live now, you're going to get to choose your own adventure this morning. So let's roll the intro, and then I have a question for you because we might have to cover one thing before we get to food court. Let's roll the intro, and then I'm going to ask. We might need to add in one thing. You're not in trouble. Law Nerds, you're not in trouble. We might need to add in one thing. We might need a minute. So I'm going to roll the intro, and then we're going to talk about it. But either way, we're doing food court. We have lots to talk about. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court. I mean, it's time. Cheers, Law Nerd. And yes, mods, I did put the Halloween goat on the Amazon list. If you want to put a link to the Amazon list, everybody's like, where do we find Emily's things? I put it on there if you guys want to find it. If you find it, I mean, I've seen them elsewhere, but if you want your own Halloween goat, I did put it on the list. All right. I wish I could link it below the video. I just can't. One of these days we'll be able to. But yes, thank you for the props on the skeleton earrings. They are very glittery. I enjoy them very much. I might wear them other times of year. But here's what we need to talk about, Law Nerds. Yesterday, a number of you, or one of you numerous times, sometimes I just can't tell, but a number of you asked about Ron. So, Law Nerds, after stream yesterday, Ron responded. Now, it's food court day, but this hit the docket yesterday. So all of the Law Nerds were just like, Emily, what about Ron? I'm like, I haven't seen anything from Ron. And then yesterday afternoon, Ron filed. So I'm going to ask if we need to cover Ron before we get to food court. I'm going to start a poll. Ron, then food court. Because some of you are like, I've been needing food court. I've been waiting for food court. We have food court. So I'm going to let the chat decide. Chat gets to decide. And then we'll turn the light. Maybe we'll just turn the lights like pumpkin orange. And then we'll just Ron first. And then we are going to cover the Liquid Death Wish lawsuit. But I think maybe also Ron has a death wish. For those of you that are like, who in the world is Ron? I'll tell you. Who in the chat just said Ron is cooked, it counts as food court. I saw another version of that. Ron is toast, it counts as food court. Y'all are thinking the same thing. Ron first, then food court. Awkward Aquarian said, every time I hear Ron, I think of Lavender Brown from Harry Potter. Same. That is why I started calling him Ron, because it's like, it's just a Ron. So for those of you that are like, who is Ron? Let me give you a quick summary. I've not finished my coffee. I was doing a podcast interview this morning. I think that'll be out tomorrow. And we'll talk about it. 91% yes. Look, we're going to end up with our code bred food fight immediately. For those of you who are like, who is Ron? Ron is an attorney. Lawnards, we're going to fly to LA real quick. We're going to cover Ron. Ron was the plaintiff's lawyer in the Cardi B case. And we were pending an order to show cause for sanctions. And his response was wild. And he has responded again. Let's fly to LA. God, I hate flying into LAX. Can we go to Long Beach or Burbank instead? Emily, we can do whatever we want. Perfect. I mean, court's in Alhambra. I think flying into Burbank would make sense. Let's go to Burbank. So, law nerds, for those of you who are like, who the hell is Ron? I've covered this a couple times. Ron is the lawyer for the plaintiff in the Cardi B case. And during the Cardi B case, I was befuddled by his behavior. And so I had Googled real quick to see when he had passed the bar. Turns out a year before I did, which means he's been a lawyer over 20 years. In that quick noodly search, it came up that a fairly significant civil case had been declared a mistrial by a judge that I actually know, had been declared a mistrial because Ron and counsel for the other side got into a physical altercation in the hallway, and the observers said that Ron started it, grabbed the other attorney and like spun him around, and his glasses fell off, and Ron stepped on his glasses in the hallway. And there was so much of a kerfuffle that the judge declared the entire civil trial a mistrial. That case is getting ready to go back to trial next year. It hasn't gone back to trial yet. And so there were things that happened in the Cardi B case that led me to question this attorney. And so when we started going down the rabbit hole at the end of the Cardi B case, Cardi B's lawyers said, but we are asking for an order to show cause regarding sanctions because this attorney violated numerous court orders. And we went through all those hearings. Or no, we went through all those filings. And in the filings that started the Ron is cooked, in the filings, Ron said, but I'm not a seasoned trial attorney. My bar card is the most important thing to me. The exact same stuff he said in the other case, where he was begging the judge like not to tell the principal or the California State Bar on him because his law license is the most important thing to him. And just think of the children. I'm a young attorney. Think of what about my reputation? He whined more than a housewife being accused of leaking information to a blogger. Like, it was wild. So we had been waiting to see what happened because at the last hearing, it was just a status hearing and Cardi B's attorney was not there. It was Has the final judgment been filed? Yes, it has. Then, and I missed this order, then the judge issued an order. So we're going to go to the judge's order, and then we're going to go to Ron's response, and then we're going to go to food court. Because the judge issued the order on the motion for the order to show cause. Remember, for an order to show cause, the order to show cause is explain yourself. And it's always an order to show cause regarding, like RE. Explain yourself about. So this would be like if you're looking at your kid who says like, I don't have any missing assignments. And then you're looking at their app being like, you have missing assignments. And then you're like, order to show cause, missing assignments. Explain yourself to me. Come and tell me what the fuck is happening. So that's the order to show cause. In this case, the judge indicated that if Cardi B's lawyers didn't ask for an order to show cause, the judge might do it himself. The judge is allowed to. The judge can say, no, I'm setting my own OSC to get in here for you to explain yourself. So Cardi B's lawyers asked for it. The judge issued an order. I saw the orders regarding the final judgment, and in the like line of orders on the court docket, just missed that this one had been filed. So I do apologize yesterday when I'm like, I haven't seen any updates. I hadn't seen this update. So then yesterday afternoon, I went back to look to see if there were any new filings, and I saw Ron's response. And that's when I saw that this order was in fact a different one and not the one that we had covered before. So the judge issued an order granting the hearing to show cause. That's not my docket at all. That's my screensaver. That's the background. Hold on, we got to refresh because somehow the third monitor is just not. It needs to be refreshed because streaming is dynamic. Like, can we just? Why are we just not finding our docket? There we go. Need a little bit of a noodly boop restart. I can't even blame it on anything. Sometimes it just happens. So this was October 20th. How I didn't see it, I don't know. It just got lost in the whole thing. Notice how the court crossed out proposed. So this is no longer a proposed order. So on the side, you're going to see electronically received. That's when the original was filed. The court just adopted the proposed order, crossed out proposed, signed, stamped. This is the order now. So the judge has issued an order to show cause hearing. To plaintiff's counsel, Ron. Defendant Cardi B, having presented to this court sufficient grounds to initiate a contempt proceeding, you are ordered to appear on December 5th at 10 a.m. in Department T. Not a joke, it's Department T. And show cause why you should not be 1, held in contempt or otherwise sanctioned, or both, for violating this court's July 30th, 2025 order precluding evidence or reference to purported gang affiliation and excluding Dr. Alex Avila as a witness. 2, held in contempt or otherwise sanctioned, or both, for violating the court's September 2nd, 2025 order in open court not to reference in his closing argument facts not in evidence. 3, held in contempt or otherwise sanctioned, or both, for trial misconduct, including in his closing arguments. The court incorporates by reference the attached October 2nd, 2025 declaration of Mr. Anderson and exhibits and affidavits. It is further ordered that. But wait, there's more. This order to show cause, together with the application and memorandum of points and authorities and declaration of Mr. Anderson, shall be served on Ron by personal service or by some yahoo.com email address that has nothing to do with his name or the name of his law firm, I don't even know, no later than November 4th, 2025 at 5 p.m. Proof of such service be filed at least 26 days prior to the hearing. So you have a month, essentially, well, less than a month. You need to serve this to make sure Ron has it in his hot little hands by November 4th. Personal service and email. He needs to be served because he is pending contempt and contempt sanctions. Miss 808 in the chat said, I have a Yahoo account. No shade to the Yahoo account, but if you are running a law firm, where is your work email? Like, this does not strike me as a work email. Where is your email at lawfirmname.com? That's no shade to the Yahoo users. Changing emails is a pain in the ass. But at business.com. Where is the at businessname.com? That's all. So this was signed, sealed, delivered by the court on October 20th. Literally sealed, literally signed. Also, I love the way that the court signs Ian and then there's just the F. It's like Ian F. You know who we are. So then, Ron responds, Emily, what response is needed? None to this. Emily, what is the proper response to this? Show up to the hearing? Emily, you said in the last filing, you read in the last filing that Ron said he had hired a lawyer, so he was not going to respond further because he needed his lawyer to respond. Yes. Law nerds, all of those things are true. And yet, here we are, not seasoned. And he said, I have a lawyer. No, chat, his lawyer has not filed an appearance. No, he hasn't. So his lawyer's not on the record yet, other than Ron saying, I have a lawyer. My lawyer will respond. I can't respond more thoroughly. My lawyer will respond. So the court set a hearing to come and explain yourself. Why shouldn't you be held in contempt or sanctioned? Are we surprised that Ron, had to have the last word? No. Electronically filed 10/27/2025 at 12 a.m. on the dot. This was filed onto the docket yesterday afternoon. So let us continue. Objection and response to issuance of order to show cause regarding Ron's trial misconduct. He is responding to the judge saying, hey, Your Honor, I object to your ruling. I object to your order. Stop it. To the Honorable Court and all parties and their attorneys, Defendant Cardi B obtained a defense verdict against plaintiff on September 2nd, 2025. Defendant made specific statements on September 2nd to all of the news stations that the parties would be walking their separate ways when she left the Alhambra courthouse. You already said that. It also isn't relevant. Also, what the fuck does that have to do with your OSC? Cardi B's not asking for the OSC. Her lawyers are. But Your Honor, Cardi said we were all going to walk away. What is this world coming to if you can't trust that in a press conference when she was clearly talking about someone else and I interpret it to be about me because that serves my purposes the best, I can't rely on that. The horror. Okay. We watched that the last time we covered this. He has not moved on. I feel like the copy paste is strong. Plaintiff agreed to move on with the understanding that the entire case would be put to bed. You lost. You lost. There's no agreement to be had. You lost. The issuance of an OSC retrial misconduct against plaintiff's counsel is extreme and inefficient. Laura M in the chat said, Lexi said this is giving TikTok psychic inability to understand. It's the willfulness of this one. Laura said they told him in court they'd be filing an OSC. Correct. Excuse me, Your Honor. Your Honor, your behavior is extreme and inefficient. Contempt would require plaintiff's counsel's conduct to be willful, which it was not. Trust me, bro. Plaintiff's counsel is not a quote, and yes, he put this in quotes for those of you listening in the background. He is not a quote, seasoned trial attorney and did not intentionally attempt to violate any court orders. Sarah Boone, I have found your appellate attorney. Ron. Sarah Boone needs appellate counsel. Not intentionally. He didn't intentionally attempt to violate it. He just did it. We watched it. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial. Your Honor, not intentionally. Also, I'm so sorry. Plaintiff's counsel apologizes in advance to this honorable court. Is he going to also tell the judge he's his favorite? Plaintiff's counsel was simply asking questions as best he could in an effort to zealously advocate for plaintiff. Plaintiff's counsel did not ask questions in attempt to willfully violate any court orders. But you did violate the court orders. There are rules on what questions you can ask, and you have to follow those rules. Defense counsel goes on and on in an effort to paint a false picture of plaintiff's counsel by presenting a total of 25 counts. Remember when he said in the last filing he wouldn't respond to these because his lawyer needed to respond? Did he have a lawyer at that time? Or was he representing to the court in a filed pleading that he had a lawyer when he in fact did not? I have questions. I'm just wondering. Count 1. Plaintiff's counsel asked one question about current, it's my italics voice, current gang affiliation. This line of questioning was drafted by plaintiff's counsel's office manager and asked in error. You're throwing your office manager under the bus? Also, if you don't have a paralegal, why? I mean, office managers, from my understanding, manage appointments, emails, billing, gathering documents, but they are not part of the legal team in that way. Office managers are great, but they're not part of the legal team. Also, Why are you throwing your office manager under the bus in a filing? Also, it's your responsibility to know what the orders are, not your manager's. Also, why aren't you prepping for trial yourself? Also, you can't just rename ChatGPT to office manager and say it's your office manager. Also, you have to know what the motions in limine say when you are drafting your question. Are you letting non-lawyers do legal work? Also, do your clients know that your office manager is writing the work that they've paid you to do? Different than a paralegal. But if this was a paralegal, I imagine that he doesn't have a paralegal, because they would be like, immediately no. But if you had a paralegal, they would have known what the motions in limine were. But I can't imagine a paralegal hanging around for this shit. Also, it doesn't matter. You're the lawyer. This is not a clerical or administrative error. This is not a miscalendaring issue. Miscalendaring issues happen. Clerical errors happen. This is not a clerical error. This is not a miscalculation of a date by 2 days because somebody counted a holiday or didn't count a holiday or whatever. My office manager drafted the line of questioning. Cardi B is the person you are suing, and you weren't drafting the questions of the defendant who you didn't depose. What? These are the main questions of the main witness. Also, for this office manager, I am so sorry. This is not professional behavior by your employer. Other lawyers wouldn't act this way. You don't have to put up with it. Throwing the office manager under the bus. He goes on to say that this questioning was immediately shot down and no further questions were asked in the area or in this area. It doesn't matter. They objected to it because it violated the court order. It doesn't matter. It doesn't matter. He goes on to say, you guys can see why I didn't read this yesterday and had to read it with y'all. So thank you for voting to cover this today. And then getting to food court. Plaintiff's counsel made a rookie mistake to ask this question. It was not asked to willfully violate any court orders. He didn't know what the court order was, is the thing. We watched it. Because he argued that this didn't violate the court order. His first argument was, excuse me, Your Honor, your order said past gang affiliation. I asked about current gang affiliation. And the judge dead ass said, nope. Read the order again. So his first argument was, I knew the order, I interpreted the order, and this is a gray zone in the order that I intentionally exploited. And now it's my office manager wrote the question. It was a rookie mistake to ask this question. You've now told the court two different stories because I remember what you argued to the court when we watched it. And in your first response, when you said, I can't fully respond, but I'm going to get a lawyer, and my lawyer will respond, you also said it was a gray zone. And now it's your office manager's fault? It's your fault. You're the lawyer. The judge again is going to be like, nope. So you've now given like 3 variations of this story. The first 2 were, that's not how I interpreted your order. You said past gang affiliation. I asked about current gang affiliation, Your Honor. And now it's somebody else's problem, right? Count 2. Oh, let's. Remember, this is plaintiff's counsel. He chose to sue Cardi B. And I am of the belief, and this is my speculation, it seems that this lawyer thought that this would never go to trial and did not plan for it to go to trial. He was like, she'll just settle. She's not the one, sir. Every time we've seen Cardi B go to trial, she wins. She's not the one. Count 2. There were so many trial documents being exchanged that this must have been filed in error. Plaintiff's counsel did not willfully attempt to present an improper joint witness list to the court. Your Honor, this must have been an error. I didn't intentionally file a joint witness list misrepresenting that the other side had agreed on the witness list, which you have to do in every trial. Counts 3 through 9. Defense counsel makes incorrect allegations about questions related to Dr. Avila. Plaintiff's counsel asked questions about Dr. Avila on the first day of trial on August 25th, which were overruled by this honorable court, see Exhibit 1. There did not appear to be an issue with asking questions or discussing anything related to Dr. Avila when the court overruled the objections on the first day of trial. But Your Honor, you allowed it once. It's fine. He's lacking any nuance in this argument. Count 10 through 25. Plaintiff's counsel presented a closing argument as best he could. I'm trying my best, Your Honor. I'm trying my best. This was a televised case with high emotions and very little sleep. All trials have very little sleep. I mean, nobody said this was a healthy profession with boundaries, especially when you're a litigator. I mean, less sleep if you're trying to catch the Dodgers game. I fell asleep. I couldn't do 18 innings. Go Dodgers. But, Your Honor, I didn't get enough sleep. Okay, counsel, don't go to trial then. There's like so many areas of law that don't involve being a litigator. Just don't be a litigator. It's like signing up to be an MMA fighter and being like, that dude hit me in the face. What the fuck? Okay, Blue Jays fans, look, I love you. I respect you. I grew up in Los Angeles. Go Dodgers. It's okay. You guys can have your opinion. Awkward Aquarian said, the Dodgers beat the Phillies. I'm legally obligated to root for the Jays. It's fine. We're not all going to agree on the sports ball, and that's okay. Look, it's part of my history is Dodgers games. So it just is. Go Dodgers. Also, Emily, what kind of Dodgers fan are you? The kind that falls asleep. Because once we've gone to 18 innings, I literally can't. I enjoy the baseball. I enjoy banana ball more. Let's be honest. When we're not there to go and eat the snacks, it's really tough. It's really tough. But it is part of my history. Anyway, back to trials have no sleep. Trials have no sleep. Allison was asking, how long was the game? It went 18 innings. It went 18 innings. I saw C-Rose said I was a Mariners fan. I'm neutral on who wins. I went to a Mariners game in law school and had the garlic fries. I smelled like garlic for a solid 3 weeks. No, legit 18 innings. Legit 18 innings. I don't know how anyone went to work the next day in Los Angeles. Also, trying to watch a game that is on West Coast time when you're not on West Coast time. Like, I think the game ran till midnight Pacific. I'm Central. Also, not knowing how time zones works. When I went to UMass Amherst my freshman year, I had lived in California my entire life. And so friends were like, hey, we're going to watch football. I'm like, great. And so in the middle of the day, I'm like, hey, are we going to watch football? They're like, yeah, later. I'm like, what do you mean later? They're like, football's not on yet. I'm like, what do you mean football's not on yet? Dude, I didn't realize how much I loved things being on, like East Coast things being earlier on Pacific time. It's so much fucking later when you're trying to do it in every other time zone. It's exhausting. I was like, but I love football in the afternoon. This is way too late. I want to go to bed. Emily, always? Yeah, always. I've always been I want to go to bed. All right. I'm sorry. I buffered because he was arguing to the court that it can't be contempt because he didn't get enough sleep. Y'all, this is how I remind you. This is how I remind you. Closing arguments were after a 3-day weekend. Closing arguments were after a 3-day weekend. Sir, what were you doing? Defense counsel argues that plaintiff's counsel's closing argument was presented in an effort to willfully present facts outside the evidence. You did that. You presented facts outside the evidence. You 100% did that. We watched it. Plaintiff's counsel did not willfully intend to present any facts outside the evidence. Any such statements were errors. It is evident that defense counsel, Mr. Anderson, has something personal against plaintiff's counsel. He's offended by your lack of professionalism, I am sure. And frustrated that he has to do more work because you won't just follow the rules. See, there are rules. And when everyone abides by the rules, things go pretty smoothly most of the time. We have seen trials where all the attorneys act professionally. And even though they zealously advocate for their clients and they disagree, things go pretty smoothly because they're all following the rules. When someone doesn't follow the rules, it makes it harder for everyone. And then rage. Because if we're not following the rules, what are we doing? Your Honor, he hates me. Ah! How can I even? Mr. Anderson has something personal against me. Plaintiff's counsel, this is Ron talking about himself as plaintiff's counsel. Plaintiff's counsel has lots of respect for this honorable court and has expressed that in this case and other cases. Your Honor, you're my favorite. You're my favorite. Plaintiff's counsel took this case on from another law firm for the sole reason of giving the plaintiff an opportunity to be heard. Sir, not every case goes to trial. And I have to imagine that the other law firm looked at the plaintiff and said, you are not going to recover in this case. This is not winnable. I am sorry that this happened to you, but you cannot go to trial on this. You cannot go to court on this, and we will not file this lawsuit. And Ron said, I will. Not every civil case should be filed. even when someone feels wronged, it does not mean there is a civil cause of action. I wonder if you saw that the celebrity was attached to it and went, haha. Just curious. Plaintiff's counsel took this case from another law firm for the sole reason of giving the plaintiff an opportunity to be heard. Plaintiff should have gone to therapy to be heard by her therapist, not a jury. Plaintiff's counsel has already lost thousands of dollars in that pursuit, even though he is struggling financially. Sir, it sounds like decisions have consequences. Katrin X said, so he worked pro bono. I think he worked on contingency, meaning if they won, he took the money. But if they didn't. Anon Mouse said, so other law office was telling her no. That's just my guess. We don't know that. But when looking at this case and the evidence that they had, I can't imagine most attorneys saying, yeah, this is a triable case. I can't. But he's just like, I took this case and lost thousands of dollars, even though I am struggling financially. If you are struggling financially, you cannot take contingency cases. That's not your client's problem. You are doing a disservice to your clients. And you put yourself in a really bad position, asked Tom Girardi. Well, you'd have to go visit him in prison to ask, but maybe go to prison and ask Tom Girardi how that went when he was struggling financially. But Your Honor, I'm struggling. It's not a good place to be in. Don't take the case. Also, the excuse after excuse after excuse after excuse isn't helping. Because the judge is going to look at this and be like, excuse me. None of this is a me problem. And if you were talking to my 13-year-old, he would have already looked at you and said, this sounds like a skill issue. And he would have given no fucks about saying it to your face. We're not even on page 6, 7. We're on page fucking 2. But Your Honor, I lost thousands of dollars taking this case. Plaintiff's counsel lost thousands of dollars in that pursuit, in taking this case, even though he is struggling financially. How are you just putting that shit on the street? Plaintiff counsel's law license is the most important thing to him, which he would never sacrifice for any reason. Isn't that exactly what you said in the other case? Plaintiff's counsel previously proceeded to trial in approximately 10 different cases in his career as an attorney. Plaintiff's counsel also served as co-counsel in several cases in his career. You should have learned being co-counsel. Plaintiff counsel's future career path is to be a judge in an effort to help people by administering justice.
Bruh.
No, sir, no. Also, if you're hoping to become a judge, it's because of the paycheck. Because you didn't really seem to be enjoying court. You should definitely not be a judge. You should definitely not be a judge. But Your Honor, think of my future career, said the 20-year attorney in his 50s. But Your Honor, my future career. The judge is going to be offended reading that. And the fact that you can't see that the judge is going to be offended reading that says a lot. Your Honor, I'm struggling financially. I want to be a Defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the course of trial, that he would report him to the State Bar of California. Defense counsel violated California Rules of Professional Responsibility 3.10. But Your Honor, think of the injustice. But Your Honor, he hates me. But Your Honor, I'm broke. But Your Honor, I want to be a judge. But Your Honor, I'm inexperienced and unseasoned. But Your Honor, I'm a rookie. But Your Honor, I haven't been to trial before. But Your Honor, he did it. Again, you are deflecting more than a housewife. And less artfully. Mr. Anderson said he was going to report me to the state bar. Gee, I wonder why. He violated, Your Honor, Mr. Anderson violated the rules. Sir, you violated the court orders. One such instance was in writing when he wrote plaintiff's counsel a letter on August 4th, 2025, making that threat. There is no question that defense counsel reported him. Oh, I'm sure defense counsel reported you to the state bar for violating the court orders. Your closing argument was inappropriate. Violating the motions in limine was inappropriate, and it happened more than once. And then you argued that it was justified. Yeah, he probably did. Also, if you're putting your financial situation on the street like that, I'm sure the state bar is like, hey, if you're working on contingency, we have some questions and maybe an audit. Also, was he threatening you or was he advising you of potential consequences? I have questions. Oh, but it's attached as Exhibit 2, so we get to read it. There is no question that defense counsel reported him. The judge is going to report you. At this time, plaintiff's counsel wants to move on and does not want to be judged twice. What? Like, but what though? He's judging me, Your Honor. I don't want to be judged twice. We're going to need a reunion with Andy Cohen. It continues. He actually says that. It continues. Preparing a formal opposition to an OSC will require plaintiff's counsel to spend thousands of dollars, which he cannot afford at this time. Numerous hours will also need to be invested fighting this on a case that should be over. You were told that this was going to happen. You've already responded to the request for OSC, and now you have responded to the OSC. Are you going to respond again? Or is your lawyer going to respond again? Plaintiff's counsel wants to move on. He doesn't want to be judged twice. The Honorable Judge Fusselman presided over this entire trial. Yeah. And said that if defense counsel didn't seek an OSC, he was going to seek an OSC. Not Jess in the chat said, will any of this move the judge in any way? It will move him towards annoyance, and the judge will have to take a deep breath and put aside the annoyance to rule on the matter. This is just going to piss off the court. And then he's going to have to go, explain to me why you violated the court order. And there were multiple violations of the court order. He continues. The Honorable Judge, who issued the order, presided over the entire trial. It would appear that this honorable court would not find plaintiff's counsel to be in willful violation. In what fucking world? The judge was going to order an OSC even if the other side didn't. He said it directly in court. The level of disconnected from reality that we are right now is wild. But the judge said, I might issue an OSC. The judge was displeased that the motions in limine were not followed. You have failed to read the room. This court would not find plaintiff's counsel to be in willful violation. He very well fucking might. And he would have cause to. But let's continue. This case is giving plaintiff's counsel a significant amount of anxiety. Your Honor, my anxiety. I'm broke. I'm unseasoned. I'm a rookie. I have anxiety. Sir, you have shown that you are willing to try to win at all costs and violate the court orders. In another case, you were called a menace in the hallways. Do your job. This case is giving plaintiff's counsel a significant amount of anxiety. Plaintiff's counsel respectfully asked this court to give plaintiff's counsel the benefit of the doubt. Plaintiff lost the case and there was no prejudice to defendant. You're missing the point. This is not a no harm, no foul situation. This is a pattern of conduct. Also, you have wasted, at least in another case, significant judicial resources and time by burning a jury that had been in trial for multiple weeks on a malpractice case. A case that is going to resume trial soon. You can't just stomp your foot and then say, but Your Honor, this is too stressful for me. There shouldn't be consequences. Dude, you're 50. Gen X doesn't claim you because, man, what is going on? It's giving always got a trophy. You chose this case. You chose this profession. No one has done this to you. And this motion reads like a 3 a.m. Reddit thread of grievances. Plaintiff lost the case and there is no prejudice to defendant. Taking cases to trial is rare and requires attorneys to be willing to do so without the fear of reprimand. That is not an appropriate statement in the context. If you don't follow the rules, then you can be reprimanded. But you can't be reprimanded, at least by the court, for taking an unpopular client. Clients have the right to counsel. Counsel has the right to take unpopular clients. But you have to follow the court orders. This is not that. Also, it's Los Angeles. Things do go to trial. Also, you don't have to be a litigator. Plaintiff's counsel is willing to provide this honorable court with proof of completion. Wait, no, let me go back. Sorry. There's fucking more. Taking cases to trial is rare and requires attorneys to be willing to do so without the fear of reprimand. Not the right time, not the right place. Plaintiff's counsel will be taking a trial advocacy class to better understand how to proceed to trial. What? It's the willful violation of court orders that are the problem. You went to law school. You passed the bar. I feel like after practicing for 20 years, you know, and that these tactics have worked. And there have not been significant enough consequences. So, look, here comes a consequence. Also, you have to do CLEs. I don't know what reporting group you were in because I don't know how the alphabet breaks down, but you have to do CLEs every 3 years. So, you should be doing your CLEs. The court doesn't give a shit if you're going to go take a trial ad class because apparently you've been going to trial with no idea how to follow the court rules and keep yourself out of contempt. Sir? This is preposterous levels of whining. Plaintiff's counsel is willing to provide this honorable court with proof of completion if that will satisfy the court. The court's going to hold you in contempt. And they should. Also, I would love to hear the conversation about when you go back to your law school and say, hey, I need to take a trial advocacy class because I'm trying to not get in trouble with the state bar. They're going to say, please don't tell people you went here. It continues to be bad for our image. Continuing on, it says plaintiff's counsel is already going to be judged by the State Bar of California. In this case or in others, I have questions. Plaintiff counsel requests that this honorable court not issue an order to show cause regarding trial misconduct in the spirit of compromise and efficiency. I don't think I've ever seen this much gaslighting in one filing. Like ever. Plaintiff's counsel is limited in his ability to provide additional information at this time as he is represented by counsel. Does counsel know that? Because no one's filed an appearance in this case. For this reason and the additional reasons set forth, it is requested that this court not set an order to show cause hearing related to plaintiff's counsel. The hearing's already set. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial. You don't just, it's too late to apologize. It's too late. This is staggering. Also, trying to throw a temper tantrum rapid fire at the court is not going to change the fact that the court made orders in the motions in limine and you did not follow those orders. Let's just focus on that. Your Honor, think of my career. Your Honor, I can't afford it. Your Honor, I'm a rookie. Your Honor, I'm unseasoned. Your Honor, Your Honor, Your Honor, Your Honor. Also, it seems that this attorney is willing to say whatever to avoid consequence, which is also a problem. There's a declaration. I imagine it's going to say the exact same thing we just read. Your Honor, this is extreme and inefficient. Contempt would require my conduct to be willful, which it was not. Your Honor, I'm too unseasoned to be willful. It's just all ignorance. I apologize for errors. I just was asking questions. to zealously advocate. This affidavit is just copy and pasted. The motion. It's the exact copy and paste. It's not. It's exactly copy and pasted. So we're not going to read the duplicative affidavit. I apologize. Exhibit 1. This is from the trial transcript. Question, do you remember the 21st day of September? Do you remember there was a period of time where elective medical treatment was not allowed? Yes. What about the cost of the treatment? Could you afford to pay, I don't know, $15,000, $20,000 to get plastic surgery for your face? No. Did Dr. Mulligan agree to treat you on a lien basis? He did. And when you got medical treatment on a lien basis, is it your understanding that regardless of the outcome of the case, you still owe Dr. Mulligan the fees for the treatment that he did? Is that your understanding? Yes. Did you see a pain management doctor for one visit? I did. Did you also treat with a different psychologist, including Dr. Alex Avila and other psychologists on October 8th, 2022 through July 2nd, 2023? Ms. Stranderson, objection, violation of the order granting the motion in limine. The court overruled. The witness, I'm sorry, can you repeat it? And then he asked again, objection, overruled. And that is the segment where those questions were overruled. I can't wait to see how the court responds. Exhibit 2. Email from Cardi B's attorney to plaintiff's attorney, Ron, on August 4th. By email. Ron. Dear Mr. Ron. That's not what it says. It has his last name, Rosen Janfaza. The consonants keep moving. Ron. Nikki. I know. No one getting out of law school would do this, Nikki. Nikki says, I'm a criminal attorney with 7 years experience. Under no circumstances would this be acceptable for me or anyone. The law nerds in the chat that have never been to law school are like, this is bullshit. Cardi B knows more about the motions in limine than Ron. Dear Mr. Ron, I am writing in response to a voicemail message you left for me at 8:47 a.m. today. First, as a general matter, I reiterate that as stated in my August 2nd letter to you, and for the reasons stated in that letter, bold, all communications between our office must be in writing. Would you trust this attorney to accurately represent phone calls? No. Neither would I. Everything needs to be in writing. I do not trust you to accurately represent phone calls. I do not want to be on the phone with you. Put it in writing. Do not call me. And they clocked it immediately. Right? All communications must be in writing. Do not attempt to call me or any of my colleagues, and instead confine your communications to email. Second, I write specifically with respect to one aspect of your voicemail message this morning, namely your threat to hold a press conference about this lawsuit and upcoming trial. Why did Ron include this email? Oh, Ron included this email to tell the court that Mr. Anderson was threatening him. That's why he included this email. And what does this email let us know? I'm writing with one aspect of your voicemail, namely your threat to hold a press conference about this lawsuit and upcoming trial. California Rule of Professional Responsibility 3.6 bars lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be dismissed by means of public communications with a substantial likelihood of materially prejudicing a jury pool and jury trial. Obviously, your threat to call a press conference about this case a week or less before trial is within that rule and prohibited. Counsel, you're calling me up to threaten to hold a press conference. Chat, do you think he was trying? We're going to speculate for a moment based on what we've seen. We don't always, but today we are. Do you think he was trying to pressure this case into a settlement? I'll hold a press conference. It won't go well for your client. Sir, you could never have calculated how well this would go for Cardi B. You absolutely did not know who you were suing and how well this case went for her. Because this case went incredibly well for her. I'm going to hold a press conference. Your client is a meanie. Okay. So then he talks about the rule of professional conduct that would prevent a press conference and would, in fact, prevent a press conference. It would. Obviously, your threat to call a press conference about this case a week or less before trial is within the rule and prohibited. Since you also state that you have received inquiries from the press, I note the same prohibition applies to you talking to the press. We reserve all rights, claims, and remedies, also including defamation, as to any statements you may make to the press or others, and the right to advise the court of your threatened press conference. Chat, I'm missing it. Where in this letter does Mr. Anderson threaten Ron? I'm missing it. I can't see it. Like, if you take the first letter, if FDM, I don't know what that stands for. Maybe if we just take the first letters, there's a threat. Is there a code? Did we just not crack the code? Because I feel like this email is just bro, you said you're going to hold a press conference. Remember, you can't do that. Govern yourself accordingly. Are you joking me? Don't.
Bruh.
It's don't do it. And Ron's sitting there going, they're never going to know. They're never going to know. It's not a threat at all. It is literally you can't do that. Stunning. Should we be surprised? No. I reserve the right to tell the court that you threatened to hold a press conference. Appropriate. Don't hold a press conference. It's inappropriate. Remember, society has rules. The profession of law has lots of them. Don't do that. It's not even if you do, I'll report it to the state bar. It's a nothing. Oh, there's more. Oh, look. There's more. Please forward the attached correspondence documents to Mr. Ron. Let me see what day is this from? Oh, this is August 4th. Okay. Sure. And then service. But his office is on Wilshire, you guys. Right across the street. It Be Fluffy in the chat said, very truly yours is the modern equivalent of your obedient servant. Mr. Anderson. He's like, no. I can't even wrap my head around the fact that these are real filings in a real case, because it feels like TV show parody of bad lawyering. But I think in the writer's room, they would say this jumps the shark. Like it's not even believable. It is not believable at all. So December 5th, my mother would be so thrilled if I was like, hey, Mom, so I'll just like, I'm gonna just hop out to California for a couple days because there's a court hearing in Alhambra that I really, really want to go see. Because what is happening? It's absolutely staggering that this is continuing with the foot stomping. And the judge has to be absolutely baffled at this response. I don't really have words for not only how inappropriate, but how baffling it is that this is the response. And the response is also, but also I can't respond. Your Honor, don't hold this hearing. I can't respond. Your Honor, don't hold this hearing. I'm too poor, Your Honor. I can't afford it. But I have a lawyer, so I can't respond fully because I have a lawyer. But also, I can't respond. It's just like, but also, he threatened me. He's obsessed with me. He's mad at me. I don't even know how you respond to this. Because it's just pick an excuse. He's just throwing all of the excuses at the wall. None of those, by the way, are explanations for the contempt. Did you not get the order? No, you got the order because you argued in court that there was like a gray zone. God, I would love to be a fly on the wall if this judge has a conversation with Judge Red Rakana about the kerfuffle in the hallway. Don't worry. I am actually getting new glasses. So, because I miss the old glasses, so I'll have a backup pair. Christy said, actually, romantic just played in my head. It's wild. And we should get to food court. Panda Law said, oh my God, I'm down the street from the Alhambra court. Maybe I'll stop in. You guys should see this in person. I'll keep you posted if the dates get pushed, because it can happen, especially as we get into December. Things tend to be like, oh, okay, we'll actually hold the hearing this other day. So I'm going to keep a close eye on the docket. Kelly Kate, Emily, did you talk to any of your former colleagues about this? Oh, yes. Oh, yes. Oh, there was conversations. I'm like, you guys aren't going to believe this. I imagine I have made at least several judges in Los Angeles be in a position where they would have to recuse themselves if Ron appeared in front of them because they have so much information about this. So really, I've just saved them. I've just saved them. Are y'all ready to talk about food court? We have food court updates. We got to talk about, I have influencer drama. We're going to talk about that in a little bit. We'll wait for a minute. We have influencer drama we need to talk about. We need to talk about Death Wish. We need to talk about Trader Joe's. We have an update in the Reese's case. Y'all can tell me how do we feel about Reese's? Do we like Reese's? Do we not like Reese's? How do we feel? Tell me in the chat, because we've got an update about the Reese's pumpkins that we covered last year. And I think we need to change the lights as we get to food court. Right? I think we do. Okay, let's change the lights. Let's do some Halloween vibes. Some of you are like, I've never had a Reese's. I mean, I guess if you're allergic to peanut butter, that would be a thing. Let's see. Halloween lights. We can do, let's see what this one is. I don't hate the green and purple vibes. It's definitely going to mess with the white balance for a minute. I don't hate the green and purple vibes. Let's see what else we got. Green and purple's number 1. We're going through different scene selections. I mean, how is that spooky? That just looks like my lights every day. Okay, that doesn't count. Let's see what the pumpkin vibes are. Ooh, the pumpkin vibes are kind of fun. Should we go with pumpkin vibes? They're different. We don't normally do pumpkin vibes. I think we do the orange. Some of you are like green and purple. Let's do orange for the first. Let's do orange for the first story, and then we'll switch to the purple and green for the next one. But I think we stick with the orange for now. I like it. I like it too. All right, let's see if we can make these go a little bit more movement, I think, from some of these, because that'll be fun. Let's see. That one's got some movement. That one's got some movement. Turn off this one. All right. So we've got a little bit of movement in the lights. I try not to move them too fast when they are on like movement mode because it makes them flicker on screen. But I think we've got some fun light vibes as I mess with the lights. All right. Emily, you should have set this up before. I should have. But I always enjoy playing with the lights. It's fun. It's always enjoyable. Let's make that one look more. There we go. More like a fireplace. Ooh, we can make that one green. Make it green. That looks too blue on screen. There we go. That kind of works. No, back to the orange. All right, I'm gonna leave it alone. We're gonna let those go. Let the lights play back there. And in our spooky Halloween vibes, get to some more. Let's see if I turn these down a little bit. Maybe we won't oversaturate the background. See, because I'm trying not to. There we go. I'm trying not to oversaturate the background too much. Good. The editors are going to be like, what have we done? We'll just leave it like this. There we go. Little more Halloween-y vibes. All right. Food court. For those of you new to food court, welcome to food court. We are going to be talking about, you're right, the purple at the bottom is a bit too bright. We're going to be talking about food cases, food-related cases, lawsuits over food, all things food. We have moved on from the rondacity to the rest of it. Let me figure out what's going on with that. There we go. That one light is doing a whole thing down there. Nope, not that one. I'm going to try to fix it real quick because it's doing literally the most. Why are we not just doing what everybody else is doing? There we go. The purple was way too much. Too much. We'll get to beef in a minute, but food court. I do not have a food court bumper. I need one, but we do not have a food court bumper. So today, time for food court. Talking about all of the, all things food and then a little bit of beef. Well, tea, donuts really, and coffee, but we'll get there. I think first we need the update on the Reese's case. We didn't get an update. I know food court does need its own bumper. We can swoop. I didn't swoop. We flew to California. We did not swoop to food court. Because last year we covered the Reese's lawsuit. And you will remember, let me just pull up the complaint real quick because we have an update. I'm going to pull up the complaint. You will remember that in this case, Reese's was sued over their Halloween pumpkins. And the lawsuit, like many of the lawsuits that we cover on Food Court, were over packaging and packaging descriptions. Now, sometimes when we cover food court, we're like, hey, that makes sense. And sometimes when we cover food court, we're like, hey, are you serious? Is this really happening? It was over this. On the packaging, they say, there's a cute little jack-o'-lantern pumpkin face. But the chocolate doesn't have a cute little jack-o'-lantern pumpkin face. How dare you? How dare you? And the plaintiffs said, look, this is habitual misrepresentations. There was an Olympic medal, and the Olympic medal looked like an exclamation point, not a medal. So, the lawsuit was over false advertising because the Reese's pumpkins and ghosts don't have faces. Yes, I'm serious. This is what the lawsuit is over. Also, I really do like the holiday Reese's. I like the percentage of peanut butter to chocolate on these. I think they're very good. The football one has no football. It looks just like the eggs. They're the same thing. The packaging is just different. So they can do it during football season and during Easter. It's the same thing. It's the same. And then there are YouTube videos. And they pulled up the YouTube videos because clearly the consumers are confused. For example, in a YouTube video called Reese's Halloween Candy Lied to Me, all caps, a product reviewer was angry after he discovered that the Reese's peanut butter pumpkins did not contain carved out eyes and mouth. So we're going by rage bait YouTube videos? Okay. Numerous consumers complained on YouTube that there were no eyes on the jack-o'-lantern face. Even a longtime purchaser of Reese's white pumpkins and Reese's peanut butter pumpkins stated, quote, it's kind of deceptive because on the front of the package, they make it look like there's a cute little face on them. And that's just not the case. I have bought these, like I said, for years now, and they do not have a face on them. I just don't think they should do that. Okay. They are arguing that Reese's does this and makes them cuter to boost their revenue. And sometimes the packaging actually shows that they don't have faces and eyes. I didn't even look at the packaging for this year. I need to go do that today. And yes, for those of you who are new to food court, Emily, are there lawyers and law firms that just do this? Yes. Yes, there are. So, they are saying that the plaintiffs never would have purchased the delicious Reese's treats if they knew that they didn't have faces on them. They never would have bought them. So they are harmed because they wouldn't have purchased them, and the labeling is deceptive. That is the argument. The advertising, they say, lied. And nobody would have purchased these if they had known that there were no faces. So this was filed. Oh, let me pull up the date that this was filed. This was filed May 17th, 2024. Let's pull up the court's most recent order from September 19th, 2025. We have an update. Let's take a look at what the Southern District of Florida has to say, shall we? Order granting motion to dismiss. This cause came before the court. Hershey's made a motion to dismiss. The court reviewed the motion to dismiss and the briefing, the law, and portions of the record. For the reasons set forth below, the motion to dismiss is granted. Is granted. It's rare that you get a dismissal at this stage, but the motion to dismiss was granted. It is, I say it's unusual. Is this a civil case? Yes. K. Lowe said, order, be so for real right now. Yes. Background, factual allegations. Footnote 1. At this stage, the court accepts the well-pled allegations in the complaints as true and construes them in the light most favorable to plaintiff. This is what we see in every motion to dismiss. Factual allegations. Plaintiffs, numerous, initiated this class action against defendant the Hershey Company, claiming that they were misled by packaging of certain Hershey products. That is, plaintiffs claimed they bought chocolate products they thought included cool carved designs on them, but were disappointed when the products did not include those designs, and therefore, in their view, were not so cool. Where's Luann when you need her? Don't be all uncool. Oh my God. The federal judge right now, they thought they were cool. And now they're like, not so cool. As alleged in the complaint, Hershey manufactures, markets, and distributes Reese's peanut butter products. Footnote 2, these include all of the Reese's things we just saw pictures of. As alleged in the complaint, we're going to skip. On October 9th, plaintiffs, while shopping at Publix, saw on October 29th, 2023, saw the Reese's peanut butter cup pumpkins for sale and believed that the product contained a cool-looking carving of a pumpkin's mouth and eyes as pictured on the packaging. So a jack-o'-lantern, not just a pumpkin. Like when I go buy pumpkins, I know that they're pumpkins, not jack-o'-lanterns, and that I have to carve them. I often don't. I just stack them on my porch. Then I break them down and put them into the tree line for the animals. That's how that goes. Continuing. They believed the product contained a cool looking carving, and they spent the, what do they say, $8 to buy them because they thought they were cool. Based on the descriptions of the product packaging, he purchased 3 bags of Reese's peanut butter pumpkins and a bag of Reese's white pumpkins for approximately $8 each. He complains that the Reese's peanut butter pumpkins and Reese's white pumpkins he purchased did not contain any of the artistic carvings of the mouth and eyes as pictured on the label. They were all blank. They were just chocolate. Plaintiff claims he was, quote, very disappointed and would not have purchased the Reese's peanut butter pumpkins and Reese's white pumpkins product if he knew they did not have the detailed carvings of the mouth and eyes as pictured on the product's packaging. What, were you trying to stage them for like an Instagram photo? Because I'm sorry that you're disappointed, but like, okay. Sorry. He was very disappointed, the court says. So sad. Publix is amazing, by the way. I really dig a Publix. If I have an option, I'm going to a Publix. I know y'all love H-E-B. I don't have any in my area, but I love a Publix. Similarly, plaintiff alleges that on November 2nd, 2023, while shopping at a Publix grocery store, he saw Reese's peanut butter pumpkins for sale. This is different plaintiff, and believed that the product contained a cool-looking carving. Well, they all thought the same thing. They all thought, that's so cool. You know what I would have thought on November 2nd when I go shopping for Reese's? Look, they're on sale. It's the only thing I am thinking when I am shopping for candy on November 2nd. Look, it's on sale. 100% what I'm thinking. Different plaintiff was shopping November 2nd, 2023, saw the peanut butter pumpkins for sale, believed they contained a cool looking carving of a pumpkin's mouth and eyes, and purchased it. And then he opened it and went, oh no. Quote, it did not contain any of the artistic carvings of the mouth and eyes as pictured on the label, and they were all blank. He was, quote, very disappointed. And he would not have purchased the Reese's peanut butter cups or peanut butter pumpkins had he known they did not have faces. Procedural history. On May 17th, 2024, plaintiffs filed a class action complaint on behalf of consumers who had purchased the product in Florida under the Florida Deceptive and Unfair Trade Practices Act. Plaintiffs allege that they and numerous other consumers purchased the Reese's products with the reasonable expectation that the products would look similar to the pictures. Accordingly, Hershey has, quote, deceived reasonable consumers, like plaintiffs and other members of the class, into believing that the products were something that they were not. I believe that they are chocolate pumpkins. They are, in fact, chocolate pumpkins. But go off then? Like, this is not the same as like the sunscreen that was marked reef safe and then it actually wasn't reef safe. This is not the same thing. On September 4th, 2024, Hershey filed a motion to dismiss before the court. A year. It took a year for the motion to dismiss to be completed. They filed it September 4th, 2024. On February 21st, plaintiffs filed a motion for class certification, asserting they have satisfied the requirements for the class action. While the motions were pending on March 10th, 2 of the 4 plaintiffs voluntarily dismissed their claims against Hershey. The other plaintiffs remain as the only named plaintiffs. 2 other people bounced out. On May 14th, the parties also filed a joint motion to stay pending resolution of the motion to dismiss. Hershey's motion to dismiss. In the motion to dismiss, Hershey alleges that the plaintiffs lack standing because they suffered no injury. There has to be harm. Trumpet Mom, 100%. Trumpet Mom said, oh, the reef safe has to be labeled correctly because the safety of the reef animals is at stake, 100%. And there is actual harm if you would not have purchased it, or if you purchase it and go out on a boat to go on a, snorkeling trip and then aren't allowed to get in the water because you have the wrong sunscreen because you bought something that was labeled reef safe. 100% there's harm there. This is not that. That was one of the ones that we looked at and we were like, ew, how dare you? How dare you charge more? Say it's reef safe and it's not. 100%. This is not that. This is not that at all. It's like looking at like a package of crackers and there's like cheese on the crackers. And you're like, wait, why isn't the cheese in the box of crackers? Because it's a suggestion of how to serve the crackers. So it's not the same. Continuing on. Hershey made a motion to dismiss saying that they have not been injured because there has to be injury. You can't sue because you're disappointed. No matter how much the lawyers think it's a good idea to sue Hershey's because you're disappointed that the pumpkins don't have faces. Ugh. Accordingly, Hershey said the only injury alleged by plaintiffs is an economic injury, but the plaintiffs here did not suffer an economic injury because they were not deprived the benefit of their bargain, where they did ultimately receive delicious Reese's candy. Hershey's is like, I bet you still ate them though. We know that you did. You still ate the Hershey's. You purchased Hershey's, you ate the Hershey's. Stop it. So Hershey said that they received the benefit of the bargain, and Hershey's goes on to say that the packaging included both carved and uncarved images with decorating suggestion disclaimers. Additionally, Hershey's points out that none of the packaging images included in plaintiff's complaint matches the actual packaging of the products that they claim to have purchased. Hershey's argues that if the entire complaint is not dismissed, parts of it should be dismissed or stricken. In response, plaintiffs contend that whether the packaging is misleading is a factual question for a jury. And they refer back to the YouTube videos of other consumers who complained. Dude, someone making a TikTok being, "Oh my God, I've been deceived," is not the same thing. Julia asked, "Is Reese's is a Hershey product?" Yes. Like fake outrage internet videos is not the same. Also, those aren't the plaintiffs. But Your Honor, see? Other people are mad. And plaintiffs claim that they have suffered injury because they purchased Reese's specifically for the cool artistic carvings. I almost said cravings. You purchased it because you wanted peanut butter and chocolate. And the products are worthless without them. They taste the same. No, Your Honor. The peanut butter to chocolate ratio is off because they didn't cut out triangle eyes. Oh no. The plaintiffs say that the decorating suggestion disclaimer was inadequate because it was teeny tiny print. Legal standards, lack of standing. The court says under Article 3 of the U.S. Constitution, federal courts may only decide cases and controversies. There has to be a problem. One element of a case or controversy requires that plaintiffs must establish they have standing to sue in federal court. Standing is a threshold question. To establish standing, a plaintiff must allege that. And we have not covered this much because all of our cases get too far down the road for us to even talk about standing. But when we back up, is there standing here? Is there jurisdiction? Like literally, is there jurisdiction? 1, has the plaintiff suffered an injury in fact? That is A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. Courts do not decide hypos. We're going to talk about that more in a minute. Courts don't decide hypos. They decide the case in front of them. JC, this one's on my list because actually this caused a bit of trouble for Red Bull. JC in the chat said, has anyone sued Red Bull yet when they discovered that it does not in fact give you wings? Yes, they did. We have not covered that case yet because it's an older case, but it's on my docket because it actually didn't go very well for Red Bull. Say Something said, Emma's helping me study for con law. Yes. Yes. Hypothetical. You cannot answer a hypothetical question. It can't be conjecture. You need a case in controversy. This is why we see people talk about test cases. This is a test case where I suspect lawyers were just like, hey, anybody mad about this? Call me. Because there are law firms that do just this. Has the plaintiff suffered an injury that is concrete and particularized, like you know what the injury is, actual or imminent, not conjectural or hypothetical? 2, the injury is fairly traceable to the conduct of the defendant. Like it literally can't be a you problem. I'm disappointed that this picture shows this. Sounds like a you problem. 3, it is likely not just merely speculative that the injury will be redressed by a favorable decision. Can you fix it? Can the courts fix it in some way? The party invoking federal jurisdiction bears the burden of proving standing. Because standing is jurisdictional, a dismissal for lack of standing has the same effect as a dismissal for lack of subject matter jurisdiction under Rule 12b-1. If at any point in the litigation, the plaintiff ceases to meet all three requirements for constitutional standing, the case no longer presents a live case or controversy, and the federal court must dismiss for lack of subject matter jurisdiction. Failure to state a claim under 12b-6. Did you state a claim that the court can adjudicate? Is the plaintiff entitled to relief? We've talked more about 12b-6 than we do about standing. And is the pleading specific enough to give the defendant fair notice of what plaintiff's claim is? It can't just be dumb. Like Hershey's got this and was like, this is dumb, but they know what's happening. Decision. Because I skipped through the rest of the law. Decision. As noted above, Hershey's argues that the complaint should be dismissed in its entirety because the plaintiffs lack standing. In the alternative, they seek a dismissal of the complaint for failure to state a claim and failure to plead with requisite particularity. Hershey also seeks to strike or dismiss the complaint's class action allegations. Because the issue of standing is a threshold jurisdictional question, this court first addresses the argument as regard to standing. Hershey argues the complaint should be dismissed because they lack standing. The court cites case law. The court goes on to say, however, here, plaintiffs indicated that they no longer intend to seek injunctive relief. Therefore, this court need only address the standing issue in connection to the damages claim. Before turning to the standing inquiry, the court also observes that in light of the dismissal of all but two of the named plaintiffs, the parties' arguments raised before those other plaintiffs were dismissed will be analyzed in the context of the two remaining plaintiffs only. Standing. Plaintiffs allege that they have been aggrieved by Hershey's false and misleading advertising. Oh my God, it's so harsh. They have been aggrieved by the false advertising because they purchased the products with a reasonable expectation that the products would look similar to the pictures displayed on the product's packaging. Plaintiffs claim that they would not have purchased Reese's products specifically. As to the remaining plaintiffs, the peanut butter cup, the pumpkins, and the ghosts, if they had known that they did not have the cute little faces. I summarized. Plaintiffs allege that they suffered damages amounting to, at minimum, the price of the products. Hershey argues plaintiffs failed to plausibly plead a concrete injury and therefore they lack standing. Hershey's acknowledges that plaintiff allege an economic injury in the complaint. Hershey's argues that plaintiffs have not actually pled concrete economic injury because they were not denied the benefit of their bargain. They bought candy, they had candy, they could eat candy. You have candy. Eat the candy. Stop being so... You got candy. They go on to say that plaintiffs paid for consumable goods and in return they received delicious, edible Reese's. This is Hershey's argument. You got candy. Here's candy. Hershey's point out that plaintiffs do not allege that the Reese's products they purchased were defective, inedible, and did not meet the taste and flavor expectations. Nor did plaintiffs allege that the products altogether lost their economic value because of the absence of the carvings. Plaintiffs argue that they have sustained injury in fact because they allege that they would not have purchased the product if they have known that they did not have cute carvings. Plaintiffs say that the products they purchased were worthless due to the lack of decorative carvings. Plaintiffs also argue that, quote, the value of a blank chocolate candy is going to be less than the value of the same chocolate candy adorned with detailed artistic carvings. Your Honor, they're not as cute. What will the gram think? This is full like camera eats first argument. Oh my God. Eat the candy and shut up. Or don't eat the candy and shut up. Either way. Y'all, why are your courts so backed up? This. They open it up and they're like, oh my God, there's no carvings. Trash. Plaintiffs cite no case law in their response to support their argument that such allegations are sufficient. I wonder why. Hershey's replies that plaintiffs' subjective feelings of disappointment do not constitute an economic injury sufficient to confer standing. Hershey also points out that plaintiffs' argument in their response that they sustained an economic injury based on diminution in value damages theory is not actually alleged in the complaint and cannot be pled in response to the motion. Stop it. You didn't argue it then. You can't argue it now. For purpose of Article 3 standing, the 11th Circuit has emphasized that economic injuries are the epitome of concrete injuries. A person experiences an economic injury when, as a result of a deceptive act or an unfair practice, they are deprived of the benefit of the bargain. Ordinarily, when a plaintiff purchases a product with a defect, the product retains some value, meaning the benefit of the bargain damages are less than the entire purchase price of the product. One exception to this general rule applies when the product is rendered valueless as a result of the defect. Applying these principles, various courts have found that a plaintiff sufficiently pled an injury, in fact, for purposes of standing, based on allegations that they would not have bought the product or would have paid less for it if not for its alleged deceptive label. So, like, if you buy a robot vacuum that does not, like, robot vacuum, it's like, but it says it, like, drives around the floor and cleans it, but it doesn't drive around the floor and cleans it. It's like, I wouldn't have bought it if I had to push it. So that doesn't work. Like, there are cases where this matters. This is just not one of those cases. Deceptive advertising has been a problem. You can't say a product does a thing that it doesn't do. Didn't they address this in Toy Story? In the Buzz Lightyear ads, they're like, hey, by the way, the toy doesn't really fly. It's in the ads, in the movie, the disclaimer that the Buzz Lightyear toy doesn't actually fly. Okay. Amanda in the chat said, I am buying some pedophores which are called witch's hat. If they aren't actually a hat, I'm suing. Signora Fortuna in the chat said, I am shopping for a robot vacuum. And you said that as I pulled it up. Oh my God. I swear I'm not looking at your screen. I've regularly been shopping for robot vacuums because mine is loud and it annoys me. But also, like, vacuuming is loud. The court is citing case law talking about where economic injury exists vis-a-vis this case. In another store another case, Valiente versus Public Supermarkets, the plaintiff purchased honey lemon cough drops, apparently attracted by the phrase honey lemon and the pictures of the ingredients and the statements that the product soothes sore throats. This is a 2003 case. Based on those representations, plaintiff believed that the cough drops contained lemon ingredients that were capable of soothing bronchial passages. The product's front label, however, disclosed that the active ingredient was menthol cough suppressant / oral anesthetic. That would be a great name for a band. The ingredient list did not include lemon. The plaintiff acknowledged that they did use the cough drops, which were not defective or inedible. The court ultimately held that the plaintiff failed to assert an economic injury because the plaintiff did not allege that the honey lemon cough drops were defective. They were honey lemon flavored cough drops. But Your Honor, there's no lemon. Was it honey lemon flavored? They say similarly, in other case, plaintiffs allege that they paid a price premium for a protein-infused brownie that were advertised by the manufacturer as containing 19 grams of protein per serving, but in fact contained less than the advertised protein content. Okay, that one I'm more mad about. Look, honey lemon flavored is different, but if you are charging more for hey, this is a protein food, and it has 19 grams of protein, and it doesn't have 19 grams of protein, People will buy it because it has 19 grams of protein. That is not it's flavored, it's lemon flavored versus the active ingredients menthol. That one pisses me off. Don't label it as 19 grams of protein per serving if it's not. How did they even find that out? Did they send it to a lab to test it? The district court found that the plaintiff's allegations that they suffered an economic injury were insufficient to confer standing because it failed to indicate that the products are defective or do not work as advertised, or are otherwise so flawed as to render them worthless. They're like, it's still a brownie with protein in it. That one makes me more mad, though. The court also noted that the plaintiff's allegations that they suffered injury under a price premium theory was not supported by the factual allegations. As in those cases, plaintiffs here failed to allege that the Reese's products that they purchased were defective or worthless. Put simply, plaintiffs do not allege that the products were unfit for consumption, did not taste as plaintiffs expected. Like, excuse me, the peanut butter cups tasted like peanut butter cups? Okay. Well, the peanut butter pumpkins taste like peanut butter pumpkins? Okay. Plaintiffs do not allege that the products were unfit for consumption, did not taste as plaintiff expected, or otherwise were so flawed as to render them worthless. Rather, they allege that they were, quote, disappointed. That the products, and I'm summarizing, weren't cute. Thus, plaintiffs' conclusory allegations as to why they have allegedly been deprived of the benefit of the bargain boil down to their subjective personal experiences of how the products would or should have looked when unpackaged. This is not enough. The court goes on. The court's not done yet. Plaintiff's complaint contains no factual allegations regarding the price they may have paid for Reese's products if they had not been marketed with the decorative artistic designs on the package. I mean, the same price as you pay for Reese's? Because they were the same price as you pay for Reese's? They bought a bag of Reese's for Halloween. They were the same price. They say the complaint contains nothing more than allegations of plaintiff's subjective belief that they paid a premium. However, mere allegations of having paid a price premium is insufficient. The court goes on with a 2025 lawsuit. Oh, a recent lawsuit. A 2025 order in a suit versus Lululemon, dismissing the complaint for lack of standing because the plaintiff's blanket allegations that they paid a price premium fail to tie any aspect of Lululemon's statements to the purported price premium that the plaintiffs paid for Lululemon products. They go on through other cases where this is happening. This is becoming the price of having a consumer product, which is why you're all paying more for consumer products. One of the reasons. Can't say it's the only reason. In short, the court says, accepting all of plaintiffs' claims in the complaint as true and viewing those allegations in the light most favorable to plaintiffs, this court finds that plaintiffs have failed to allege facts demonstrating a concrete injury. Therefore, the court finds that plaintiffs lack standing and lack the standing to assert a claim for relief, footnote 3, either individually or as a class action. As set forth above, plaintiffs state that they do not intend to pursue any claims for injunctive relief. Great. No standing. Leave to amend. In their response, plaintiffs request that in the event the court dismisses any of the plaintiff's claim, the court do so without prejudice to permit plaintiffs leave to file an amended complaint. Because standing is jurisdictional, a dismissal for lack of standing has the same effect as a dismissal for lack of subject matter jurisdiction. A dismissal for lack of subject matter jurisdiction is not a judgment on the merits and is entered without prejudice. Therefore, the complaint will be dismissed without prejudice. However, with respect to request to permit plaintiffs leave to file an amended complaint, defendant argues that it is not legally proper This court agrees with defendant. Leave to amend should be freely given absent a showing of futility to amendment. However, our precedent is clear that a request for leave to amend embedded in an opposition memorandum does not properly put the issue before the court. This is sassy federal judge. Like, this is federal judge, literally, as Chat said earlier, be so for real. Like, be so for real about your pumpkins. There are cases that need to go to court in product liability. There are products that are mislabeled. There are ingredients that can cause people harm. There are products that can cause people harm. Products liability is a whole treasure trove of horrific shit that has happened. This is not that. Shut up. Look, even when you get to labeling cases, if somebody's saying that you are buying, 16 ounces of pasta and it's 12 ounces of pasta, you're paying more and not getting what you paid for. Fair. It is about the pasta. But stop it. Stop it on this. The court goes on to say that because plaintiff's request for leave to amend is embedded in their response to the motion, it is not procedurally proper and will therefore be denied. Untimely. Just yeet. I'm not granting you leave to amend. However, it is dismissed without prejudice, so they can amend. Conclusion. Defendant's motion to dismiss is granted. The complaint is dismissed without prejudice. In the event plaintiffs intend to seek leave to file an amended complaint, they must request leave to do so in a properly filed motion in accordance with the applicable federal and local rules within 15 days. The clerk of court is directed to close the case. All pending motions are moot. They filed notice of leave to amend. They filed notice of leave to amend. So even though it's closed, it's not closed because the court may yet grant leave to amend, or they might have to file another suit. They are not precluded from filing another suit. Here is the thing. I did not pull the statute of limitations on this. These purchases were made. I mean, this doesn't stop somebody from purchasing them this year and bringing another lawsuit, but these purchases were made in 2022. So you don't get the benefit of the filing date, but they filed asking the court for leave to amend. Hershey's also filed saying, pay us our fees. Shut the fuck up. Pay us our fees. Pay us our fees. So with all of that, the Hershey's case is closed, but not closed. Closed, but not closed. Let's get to a poll real quick of which you want to cover next. So I'm going to put up a poll in the chat real quick. And we are going to zoom through those a little faster. We actually learned some law in this one. The other two were just looking at complaints. There's no resolution. They're both new. Let's see. And I'm not telling you what I'm putting in the poll so that we can just do the poll, because otherwise it'll just be in the chat and then I'll be reading the chat, not the poll. Let's see. Liquid. All right. Here is the poll. Which case are we covering next today? Trader Joe's sued over sandwiches, Liquid Death, Death Wish, Death Match. Which one? Which one? And then we need to talk about Spidey D. So we're going to talk about these two, then we're going to talk about Spidey D. I'm going to answer a few questions while that poll is up. I'm going to pronounce this terribly because my brain can't at all put the letters in the right place because it's that kind of a day. It's my kiddo's 5th birthday today. Love from BC. Happy, happy, happy birthday. Happy birthday. Pen Monkey said AI products have more false advertising than this. It's fair. Hope Martin said, if offered a bag with faces, would that be enough? No, because there's still not injury. So even if they said this is the actual bag we bought, there's still no injury. So Crazy Cat Queen said, I would argue, EDB, Red Bull does give you wings, just not the big ones on your back. It gives me flutters in my heart, the uncontrollable kind, or the uncomfortable kind. Yes, too much caffeine. Tyrone said, how is this a lawsuit? Should it not just be a refund at most? Because lawyers. There are lawyers who are like, we're going to sue Hershey's because the picture has a face and the candy doesn't have a face. Because you can, who's watching Real Housewives of Salt Lake City? How many times this season of Real Housewives of Salt Lake City have you heard anyone can sue anyone for anything? Right. Emily Outdoor says, my bag with faces says decorating suggestion. And that's why when you see like a box of crackers with different things, it says serving suggestion, because people will actually sue and be like, but on the box, the crackers had stuff on them. Why is the stuff not in the box? And you will see boxes or advertisements for like a phone case. And there's a picture of it in a phone and it will say phone not included, case only. We're going to do both cases. A couple of you in the chat said, can we do both cases? We're going to do both cases. I was just asking which one you wanted to do next. We're just giving you an order. You get to pick the order. Casey Cat said, just looked at the back, goes pumpkin packaging, now shows an imagined mouth, eyes, nose with peanut butter coming through. Basically do it yourself. Yep. Crazy Cat Queen said, I spent a lot of my childhood in Japan. First time I got a holiday Reese's, I too was disappointed. I did think it was false advertising, but I was spoiled in Japan, so I just got over it. Right, because Japan lives in the future and has all the coolest products ever. It's fair to be like, the products here suck. Anne said, in honor of food court, I picked up my own Spidey D Dunkin at Munchkins. It was a must despite having to get up too early to do it. They sell out pretty quick every day in our area. They really do. Emily Outdoor said, I bet this person is heavily involved in their HOA. Margaret in the chat said, my 10-year-old grandson said, just eat the candy. Right? There are some things that are a problem. Some people can be injured if you don't label things correctly, especially when it comes to food ingredients. This is not that. This is not that. This is not that. MB said, in Japan, the picture of the item on the package have to be the same size. There are newer regulations in the US about that. If the picture is enlarged, there is a statement that it is enlarged to show detail. You have to specify if you have enlarged things. So yeah, I think it's fair that packaging shouldn't be deceptive. I also think that there are boundaries to that. Sherry said, I ate at Chili's last week and my salad had pieces of broken plate in it. And of course, I bit down on it. That's not good at all, Sherry. I also was traumatized last week at Chili's, but nothing like this. I haven't been to Chili's in a million years. Emily, are we telling this story for food court? Yes, because I might sue someone. I have not been to Chili's in 10 forevers. Dr. B is not a huge fan of Chili's. It is just not on the regular rotation. Haven't been in Chili's in forever. So I was at a band competition with Chris, who was in town, and we were looking for some food in between things. And I pulled up like the area that I wanted to go over to. And I was like, hey, there's a Chili's. I want to go sit down. Let's go. I haven't been to Chili's in forever. I love their queso. Queso and chips and like a quesadilla sounds like the best lunch ever. Can we just have 3 courses of cheese? Let's go. Let's go to Chili's. And she's like, literally down for whatever. Let's go to Chili's. So we go to Chili's. Was very excited to go get some queso. They changed the queso. This month, they changed the queso. Some of you are saying in the chat they brought it back. Not on Saturday. Haven't been to Chili's in a million years. Sit down with friend Chris. Hungry, band comped, ready to have, some queso, and I look at the menu and it says new Southwest queso. Can I get the old one? Can I get the old one? The meat one was gone. That is what I went to Chili's for. I haven't been to Chili's in like 10 years. And I was like, all I wanted was the queso. And I opened the menu because I didn't even think to pull the menu up online. I opened the menu and it was new. I'm like, I don't know. I don't want the new one. I want the old one. Damn it. I know they are now bringing it back. I was not the only one I think that was outraged. But the new queso is fine. But it's not the old one. And it is just basically the nacho cheese that I would hand to you at the high school football game when I worked the snack stand. It is snack stand nacho cheese with like Southwest chilies in it. It is not skillet queso. It's sure the fuck not. The skillet queso, by the way, the skillet queso is specific. And if you're like, I want skillet queso, and you go in and it's like, new, you're like, fuck. So apparently they're bringing it back. But I did not want the new queso. I did not want the new. Look, man, I'll just get nachos at the football game this week. It's basically the same. I was so disappointed. So no, the skillet queso was gone. The bloomin' onion also gone. Like a whole bunch of stuff was gone. I was like, what? And then Chris was like, I don't think I've been to like Chili's since like I want my baby back ribs. And I was like, fair. I want my baby back, baby back, baby back. Katie in the chat said, oh, so Velveeta and Rotel, yes. It was disappointing. I actually said this when we were sitting there. And Lynn said, I worked 10 hours. All I want is queso. Yeah. I worked 10 hours. Oh. I sat in stadiums all weekend at band competitions. And it was cold and then it was hot and then it was cold and then it was hot. I just want some freaking chips and queso. Damn it. No, not the Chili's. What is the Chili's equivalent of the little onion thing? Because they have an equivalent. That one was gone. Either way, disappointed. Not the same. They also don't have the avocado egg rolls anymore. It seems like they probably simplified their menu to reduce overhead. Like when I was looking at the menu, I'm like, oh. The quesadilla was actually really, really good though. The Awesome Blossom, thank you. The other blooming onion. Blooming onion, Awesome Blossom, I use them synonymously. But I would be more traumatized by having like glass in my plate. Happened to Dr. B once. We were out to eat and there was a quarter that he bit down on that was like in his soup. Dr. B was not thrilled. And I was like, I'm sure somebody leaned over and it fell out of their pocket, but also, nope. So anyway, I was very sad. I was like, well, it'll be another 10 years. A quarter. He bit a quarter. Took a bite of soup, bit a quarter. It was the end. I was like, oh my God, he did not crack a tooth. Thank God. But he was just like, ugh. And I'm like, right, this is disgusting. Stop eating the soup. And we're done for the night. No, Dr. B didn't sue. Dr. B said, yeah, we're going to need to go. But it kind of killed the vibe on date night because he was just like, yuck. All right, let's see where we're at with the chat. 53% of you are like liquid death, death wish, death match. How many times am I going to say that? Well, once he felt the quarter in his mouth, Aaron, it ended up in his mouth, but it was also if I am correct, it was some type of a lobster bisque with pieces of lobster in it. And then a quarter. So, liquid death, death wish, death match. We're going to have to talk about this one. Law nerds, are you ready? Let's go. Remember our conversation about standing. Yes, because we are going to have to talk about standing as we talk about this lawsuit. We will also talk about comments made on social media. I do not always pull up comments made on social media about lawsuits that we're covering, but for this one, we're gonna. 100% gonna. Because Death Wish seems to have a death wish and is decided to take the fight to Liquid Death. For those of you that are not familiar with these two brands, don't worry. The lawsuit is going to fill it in for us. And yes, one of my favorite things about Food Court is that most of these lawsuits come with pictures, which I think is fantastic. I love pictures. I'm here for it. So, Death Wish Coffee versus Liquid Death, aka Supplying Demand Inc., which I think is a very clever business name. I am not mad at it at all. This one is in federal court in California for trademark infringement, false designation of origin, determination of non-registrability of trademark, declaratory judgment, and unfair competition. Also, I will say, Death Wish coffee is even too caffeinated for me. Liquid Death is something I very much enjoy when I go to concerts. And we just bought the new Liquid Death soda flavored waters. The Dr. Death soda flavored water is actually really good. Travis was like, we were looking for a non-caffeine alternative for the evening, but Travis was like, damn, this was good. A lot of you in the chat love Death Wish coffee. I do not have a Death Wish, but I do like the Dr. Death. It's really good. So, plaintiff Death Wish Coffee brings this complaint against Liquid Death and alleges on personal knowledge as to its own actions and on information and belief as to the actions of others. Introduction. So what do we got? Trademark lawsuit. Death Wish is one of the largest and most successful premium coffee brands in the country. Since its founding in 2012, it has sold critically acclaimed coffee under its unique Death Wish Coffee Co. registered trademark and associated mark, the Death Wish marks, at thousands of major retail locations nationwide and online. Yes, I see it regularly at Publix. Death Wish brings this action to enjoin Liquid Death from confusing consumers and trading on Death Wish's brand and goodwill by launching competing Death-branded coffee beverages. We have the death. It is our death. You cannot have death. No death for you. Too much death. Straying from its current business of selling sparkling waters under the Liquid Death brand, excuse me, they also sell flat water and flavored water. Sparkling, flat, flavored. Not just sparkling water, but okay, go off, I guess. Straying from its current business of selling sparkling water under the Liquid Death brand, Liquid Death recently applied to register the trademarks Liquid Death and Liquid Death Deathachino, which they did. It's pending. It's a funny name. They have some other ones pending. Do you want to know? Do you want to know what else they registered for? Hold on. Let's see if I can pull it up instead of making you watch as I swipe across the screens because it's in a different tab. Emily, what tab is it in? I don't know. Hold on. Too many tabs. There it is. Do you want to see what other trademark registrations they recently filed for? Should we? I think we should. Let's look real quick. Also, I like the redesign of the TESS system. So, Liquid Death Deathachino is pending. They also have Liquid Death in the area. No! Why? The website is so mad. Can you just give me back my Liquid Death marks, please? Damn it. They have a few other pending trademarks. Hold on. Let's just do it this way. They have all their Liquid Death ones. They have their Liquid Deathachino, which is what's pending. They have Liquid Death Scream Soda pending, which I imagine is a cream soda. They have numerous brands. Of course they do, because trademarks under the Liquid Deathachino. Liquid Death Scary Strawberry. The last one down here that's cut off is Liquid Death Tropical Terror, Liquid Death, Unsweetened Reaper, iced tea, Liquid Death Sinister Ginger, and Liquid Death Mountain Don't. They also have a Liquid Death Orange Horror and Liquid Death Murder Mystery and Liquid Death Kilbert Grape. I imagine those are all going to be soda flavors or soda water flavors. As I said, the Dr. Death is actually pretty good. They also have a Raspberry Rage iced tea. So Raspberry Rage iced tea, Liquid Death Orange Horror, probably an orange soda in the vicinity of Fanta. Liquid Death Murder Mystery, not sure, very curious. Liquid Death Kilbert Grape. Liquid Death Strawberry Terror. What, like strawberry Fanta? Liquid Death Mountain Don't, Sinister Ginger, Unsweetened Reaper. So, and there's a Death Island, which is also a tea. This is Liquid Death Island. Tropical Terror. Is there a PR list? I want to be on the PR. Can I be on the Deathachino PR list so we can tell you what we think? I'm also curious about the Scream Soda. But the Deathachino name is fantastic. But it does say non-alcoholic beverages flavored with coffee and coffee-based beverages. So they have registered in a few categories. They are pending. The names are great. I love them. So I'm very curious. Dotella said I may buy them specifically for the puns. Yep. And the soda-flavored waters are 0 sugar. They were really good. So, or 0 adjacent. They have like 5 or 10 calories a can. So limited. But the cans are funny. So the registration of the pending Deathachino marks is one of the things that the lawyers are going to be looking for, because the lawyers in the space of Death Wish are going to be looking for competing marks, and these things get published while they are pending. BS said, oh my God, I'm drinking cherry obituary right now. There we go. So, continuing on. Death Wish brings this action to enjoin Liquid Death from confusing consumers and trading on Death Wish's brand and goodwill by launching competing Death-branded coffee beverages. Because they've registered Deathachino with U.S. PTO, Patent and Trademark Office. Not paid time off, y'all. They want to use Liquid Death Deathachino in connection with coffee and coffee-flavored beverages. Upon information and belief, Liquid Death intends to launch these infringing coffee products in a matter of months, in or around January 2026 or soon thereafter. Oh no. I like their water. I do. I enjoy Liquid Death. I enjoy the cheeky marketing. The infringing, I should have grabbed one before I started streaming. Fail. The infringing coffee products will confuse consumers, they say, infringe the Death Wish marks, and irreparably harm Death Wish and its valuable brand. The infringing coffee products will duplicate the dominant element of Death Wish's registered trademark, i.e., death. We own death, fuckers. You can't have it. You can't have death. We have death. We have death in beverages. No death for you. They will likely appear in the same retailers and side by side with Death Wish's products in stores, where Death Wish sells both ready-to-drink canned coffees as well as other coffee beans and coffee products. And they will share similar consumer bases and advertising, distribution, and marketing channels. Liquid Death is well aware of Death Wish's established trademark rights in the coffee market, but plans to launch infringing coffee products anyway. In short, okay, this is kind of funny. I don't know how I feel about this yet. I haven't read all of this yet, but I don't mind the cheekiness. In short, this is a dead to rights case of willful trademark infringement. It's a good line. It's a good line. I don't know how I feel about this lawsuit yet. We're going to keep reading it, but the dead to rights is a good line. I mean, 10 out of 10, counsel. I don't know how I feel about all of it, but again, if you don't protect your trademarks, You can lose your trademarks, but the dead to rights is a good play on word. This is a dead to rights case of willful trademark infringement as illustrated by the striking similarities of the parties' existing trade dress. When you look at them, I have no confusion. I have no confusion about what is a death wish product and what is a liquid death product. They think there is death confusion. Do you have death confusion? Their products, when you look at them on a shelf, you do not look at Death Wish and go, oh my God, is that liquid death? And you don't look at liquid death and be like, oh my God, did Death Wish make water? They're in a can. It's about it. The branding is different. The lettering is different. Remember the cookie wars, where one of the arguments in the cookie wars was like, we put our cookies in a rectangular box and they put their cookies in a rectangular box. Oh no. I mean, when you look at them, you're just like, the branding is significantly different. Death Wish Coffee thinks that this is a dead to rights case of willful trademark infringement as illustrated by the striking similarities of the parties' existing trade dress, which Liquid Death has indicated is representative of the infringing coffee products. Prior to filing this suit, Death Wish requested... No, you didn't. No, you didn't. Death Wish requested that Liquid Death voluntarily refrain from launching the infringing coffee products and withdraw its applications. Can you imagine those lawyer letters? Lawyers. I promise I won't tell anyone where they come from if you send them to me. What did that letter look like? Can somebody please? Oh, it's probably seen as a settlement agreement, which would be confidential. But if they were not in settlement agreement, can you please? I really want to know what Death Wish lawyers said, because I bet you it ended with govern yourselves accordingly. As you know, we are Death Wish. You are a water company. I'm going to need you to not launch a coffee product. Pull out now. Pull out immediately. So Death Wish reached out to Liquid Death and told them to withdraw their infringing applications. Liquid Death refused to do so and has confirmed that its coffee products are forthcoming and will be made available in the marketplace. Do you think they just sent back balls, period? Or was it, wait.
Nope.
Was that it? They just emailed back.
Nope.
Nikki Crayon said, no, they said, hold my water. They said, hold my coffee. The lawsuit goes on to say, meanwhile, in a sign of its disregard for Death Wish's trademark rights in the coffee space and as a harbinger of deliberate infringement to come. Okay, look, again, I'm not sure how I feel about this lawsuit, but I'm not mad at the lawyering. Look, the death-related languaging is a 10 out of 10. It's just a 10 out of 10. The harbinger of deliberate infringement to come, Liquid Death has begun advertising its non-coffee energy drinks by claiming that they feel like coffee. Wait, they have energy drinks too? They do? I didn't know that. I thought it was just water and like soda flavored water. Some of you are like, Death Wish is just jealous. But the language is great. The dead to rights, the harbinger, I'm not mad at it. 10 out of 10 on the lawyers who are like, we have to defend our trademark. The writing is pretty funny because they do have to defend their trademark. They go on to say Liquid Death has begun advertising its non-coffee energy drinks by claiming they will feel like a coffee. It has caffeine. Death Wish therefore brings this suit to halt. You mean to kill? To kill Liquid Death's willful infringement? and seek preliminary and permanent injunctive relief. Your Honor, tell them they can't make coffee to prevent the irreparable harm that they will suffer. The parties. Death Wish, Liquid Death. Liquid Death does business under supply and demand out of California. Death Wish is out of New York. They are a premium coffee roaster, they say. Jurisdiction, we're not going through. Facts, Death Wish, marks and brands. Death Wish shows its different trademark registrations and what those registrations look like. Death Wish Coffee Company, Death Wish Coffee with the skull and crossbones. They say Death Wish Coffee Company with beans, etc. So they're showing the different registrations, including Death Cups, like coffee pods, and then Ginger Dead. Class 30 for coffee, espresso, tea, cocoa, coffee-based beverages. So Ginger Dead, those are their trademarks. They are saying that Death Wish has received widespread praise. I call this the resume portion of the lawsuit. Your Honor, we're amazing. They suck. They're going to ruin our amazing because we're amazing, Your Honor. We're the death brand. Fuck those other death brands. We're super cool. Your Honor, we've received widespread praise and we've been featured on Good Morning America in 2016. We're the smallest company to ever run a TV ad at the Super Bowl. And we have significant social media engagement with hundreds of thousands of followers on Instagram and TikTok. Your Honor, we're popular on TikTok. And we have received multiple product awards for best of lists across numerous websites and publications. Just a note, a lot of those are paid to play. Get me started another day on how much the Emmys are trying to charge people to get a podcasting Emmy. You have to pay a significant amount to apply. We can talk about the pay to play later, but a lot of those best of lists are pay to play or affiliate links, but I digress. Today, Death Wish products are sold throughout Death Wish Coffee's own website, via online retailers, and in retail chains. How dare they? Walmart, Kroger, Target, and Albertsons. You don't even list Publix? Publix! It's time to take a stand, Publix. Are you going to sell Death Wish? Or Liquid Death? Whose side are you on, Publix? They didn't even name you in their lawsuit. The disrespect. Okay. Death Wish diligently protects its trademark rights. They have to. When Death Wish's success spawned attempts at imitation, Death Wish has enforced its trademarks against would-be infringers. They must. As a result, Death Wish's extensive promotion of its intellectual property and widespread success, the Death Wish marks are among the most unique and valuable brands in the coffee industry. Your Honor, we're more valuable than Starbucks. As a result of Death Wish's extensive promotional... Oh no, I already read that. Defendant Liquid Death. Defendant Liquid Death is best known for selling sparkling water under the Liquid Death brand. Liquid Death claims to have begun its selling of sparkling water products in 2019, years after Death Wish adopted and registered the Death Wish marks for coffee. Didn't Liquid Death spawn out of like a metal record label, though? Anyway. While Liquid Death was years behind Death Wish Coffee and adopting a death-centric brand. Oh my God. Years behind. Liquid Death was years behind the death-centric brand. The two companies have coexisted because they operate in wholly different market areas. One sells coffee, the other sells sparkling water. The situation even produced some friendly ribbing on social media, as demonstrated by the following March 2nd, 2022 exchange on Twitter, now X, Bird app. See, mutual recognition. Death Wish Coffee Company at Liquid Death. How does it feel to be the world's weakest coffee? Liquid Death at Death Wish Coffee. We're actually water, not coffee. Hold on. I zoomed out too far. And without water, you are not coffee either. You'd just be Death Wish beanbags. Okay, look. How does it feel to be the world's weakest coffee? We're water. And without water, you're not coffee. You're beanbags. Look, Your Honor, our social media people had funsies on Twitter once. We were flirting. Your Honor, it was all fun and games till they decided to make coffee. We thought we could get along. And then they came for us, Your Honor. They want to make coffee too. Okay. They're going to make a deathachino. As Liquid Death acknowledged above, Death Wish and Liquid Death have been able to coexist because Liquid Death's products are water, not coffee. Your Honor, they said they're not coffee in a tweet in May of 2022. Your Honor, in 2022, they said we're not coffee. Jell-O could never be creme brulee, Your Honor. That analogy doesn't work because water can in fact be fucking coffee. But Your Honor, Jell-O could never be creme brulee. Water can't be coffee. Water can't be coffee, beanbag. All right. Your Honor, they want to be coffee and they can't be coffee, Your Honor. We're the only death coffee. Come on. The coexistence is coming to an end. Flush with investment valuing the company at $1.4 billion. Liquid Death is prepared to invade Death Wish's market territory by infringing Death Wish's trademarks by selling death-branded coffee. Your Honor, they're more popular with the VC. Sad. They're worth $1.4 billion. They're going, Your Honor, I'm just a baby. The water is going to squish us. No. On May 2nd, 2025, Liquid Death filed for a host of death-formative trademark applications for coffee beverages with the U.S. Patent and Trademark Office, 2 for Liquid Death for coffee-based beverages and non-alcoholic beverages flavored with coffee, and 2 for Liquid Death Deathachino. In connection with each of the applications, Liquid Death submitted a sworn affidavit that Liquid Death has a bona fide intended use of the mark in commerce. These are intent to use marks, and has a bona fide intention to use the mark in commerce. They're going to make the product. They're not just holding on to it. They're going to make the product. This fits Liquid Death's pattern of applying to register for trademarks ahead of launching products. Literally fucking everyone does that. Everyone does that. Everyone does that. That's what people do. This fits Liquid Death's pattern of applying to register trademarks ahead of launching product line extensions as part of retail sales in January of the following year. For example, Liquid Death applied to register trademarks for its Root Beer Wrath, Dr. Death, and Killer Cola soda products in July of 2024. They launched the products in January 2025. Right. Because they don't want people to grab the URLs or make merch or compete with it or file trademarks that are going to be harder for them to file. Yeah. Liquid Death applied to register trademarks for its forthcoming energy drink products. Oh, that's what those are. We didn't go through them. Liquid Death Scary Strawberry and Death to Drowsy in June 2025 and recently announced the products will be released in January 2026. In light of Liquid Death's May 2025 filing of the infringing application and its history of similarly timed product launches, Death Wish is informed and believes that Liquid Death intends to launch the infringing coffee products around January 26 or soon thereafter. Death Wish's good faith efforts to avert litigation. Prior to filing, oh, please attach the emails. Please tell me more. Prior to filing, Death Wish Coffee contacted Liquid Death to request it desist from its planned infringement. Do not infringe upon me. Go away. Back to the water aisle with you. Death Wish Coffee's counsel sent a letter to Liquid Death's in-house counsel. Talk about a job. That would be fun. Detailing Death Wish Coffee's trademark rights and explaining the confusion that would ensue if Liquid Death proceeded to launch. Exhibit 1, July 29th letter. Wait. I'm on page 8. Is it in here? No. I might have to go back to Pacer. I want the letter. I didn't see it on the docket. We're going to have to go back to the docket. I want the letter. They say it's attached. We're going to go find it. Emily, really? Yes, really. I want the letters. I 100% want the letters. Let's finish reading this and I'll go find the letters. Wait, what page was I on? Damn it, I said I was on page 8. There we go. I'm going to have to go find the letters on the docket because I did not see them, but the exhibits aren't attached here. I'll go find them. On August 5th, Liquid Death's in-house counsel responded via email and stated that Liquid Death would not provide a substantive response until September 5th, 2025. On August 7th, Liquid Death assured Death Wish Coffee that it would not launch the infringing coffee products in the interim. Hey, we're not launching it today. No worries. On September 5th, Liquid Death sent a letter responding to Death Wish Coffee's cease and desist. The letter confirmed that the infringing coffee products are forthcoming and will be made available in the marketplace. Liquid Death's letter also generically denied that confusion was likely and included the following comparison to illustrate that the infringing coffee products would look like side by side. Picture. Next statement. Given the striking similarities of these products, the example provided with Liquid Death's letter only confirms that the infringing coffee products are likely to cause confusion. The skull and crossbones and the sideways dripping skull are not the same. The font is not the same. The vibes are not the same. The shape of the can is also not the same. And the top of Liquid Death's cans are all gold. So even the way that the cans are produced are not the same. Like the Death Wish Circle and the Liquid Death Old English are just not the same. The vibes aren't similar. In subsequent correspondence, Death Wish has implored Liquid Death to abandon its unlawful plan to infringe the Death Wish marks without judicial intervention, but Liquid Death has refused. Exhibit 2, September 30th letter. Meanwhile, in a sign of its disregard for Death Wish's trademark rights in the coffee space and a harbinger of deliberate infringement to come, Liquid Death has begun advertising even its non-coffee energy drinks by claiming that they feel like coffee, including the following image posted to social media by Liquid Death's CEO. They actually did put a box around the word coffee. It says, a better for you energy drink feels like a coffee, not like an electric chair. That is what the entire ad says. It goes on to say, given Liquid Death's refusal to abandon its launch of infringing products, Death Wish has no choice but to bring a suit to prevent confusion. Remember when the theme park Evermore sued Taylor Swift over the album Evermore and was like, but people are going to think the Taylor Swift album is the theme park. That happened. The infringing coffee products will infringe the Death Wish marks. So Death Wish goes on to say, look, they are infringing on our marks. We are a unique brand. We are widely popular. We are recognized by the public. Well, if you're popular and recognized by the public, they're not going to confuse Liquid Death. But Death Wish does not agree. Death Wish says the Death Wish marks are in danger of being swamped in the coffee marketplace. You mean buried? Buried in the coffee marketplace? That one was a little suggestion. By Liquid Death's massive promotional spending. Liquid Death has attained prominence in the sparkling water category by inundating internet media and other advertising channels with its promotions for Liquid Death because it's funny. Their marketing is funny. When Liquid Death aims this massive promotional machine at the market for coffee beverages, it's likely to cause reverse confusion and deceive customers into believing Death Wish and the Death Wish marks are associated or affiliated with Liquid Death. Your Honor, they're more popular than we are. The Liquid Death and Death Wish Deathachino marks are highly similar in sight, sound, and meaning to the Death Wish marks, including Death Wish Coffee, Death Cups, and Ginger Dead. Ginger Dead and Deathachino don't sound the same to me. Death Wish and Liquid Death also don't sound the same to me. Among other similarities, the infringing marks duplicate the dominant element of the Death Wish marks, i.e., death. Your Honor, they're trying to take our death. Don't let them have our death, Your Honor. We make the deadest coffee around. They go on to say the similarity is not merely theoretical. Mainstream publications have already juxtaposed the parties. I'm sorry. What word? Juxtaposed? Oh, so they're comparing the two because they know they're not from the same origin. So it's a comparison. So they know that like the Deathachino is not a Death Wish product. You kind of said the quiet part out loud there. They say the similarity is not merely theoretical. Mainstream publications have already juxtaposed the parties' respective death-branded products. For example, Men's Health recently ran an article profiling the two companies' punk rock style. I mean, isn't Liquid Death a bit more metal? Chat, let me know. Are we more metal or are we more punk rock? Either way. Profiling the two companies' punk rock style, death-branded beverages side by side, highlighting their nearly identical aesthetic. No. Dude, no. And shared emphasis on irreverent death-themed branding. Such real-world press coverage underscores that consumers and even seasoned media outlets already perceive a close association between the brands, confirming that confusion is likely. Marketing channels. The infringing coffee products will share similar or identical marketing and distribution. Your Honor, they're gonna do things on Instagram and in grocery stores. Coffee and water are sold in the same place. Damn it. Our types of good are the same. Liquid Death is going to infringe. They go on to say that they face irreparable harm if death isn't stopped. Wait, no, that's not what they say. If Liquid Death isn't stopped. Your Honor, you must stop her death, or we will be harmed. It will be the death of our brand. We will be 6 feet under, Your Honor. Your Honor, we do fear the Reaper. And in this case, the Reaper is Liquid Death. It's coming for us and our share of the coffee market. And it's going to underscore our hard-won goodwill and reputation. That was my summary. First cause of action, trademark infringement. Second cause of action, false designation of order. Remember the purpose of trademark, back to the law. The purpose of trademark is so that you know the thing you are buying is from the company you think you're buying it from. So you are not buying something going, wait, what the fuck? If you're buying a cola on a red can with white writing on it, you're like, oh, that's a Coke. But if it doesn't come from the Coca-Cola company and you're looking at the can and it doesn't come from the Coca-Cola company, you're like, wait, what the fuck? It is so that you know that the product that you are buying is from the person that you are buying it from. Designation of origin. Is the water that I'm buying from Liquid Death? Or is it from Dasani, which is unacceptable in all circumstances? Emily, you absolutely hate Dasani. I do. I really do hate Dasani. It's like walking up to somebody and being like, Hey, is a Pepsi okay? No. No, it's not okay. I know there are 7 of you in the chat that enjoy Pepsi. Look, sure. But if I ask for Coke and you say, is Pepsi okay? The answer is no. It's not. But thank you for designating the origin. You didn't just say, oh, here's soda. You realize that there is a difference between Pepsi and Coke. And even Coke can be wrong sometimes. C.E.G. Dasani. But I don't think anyone's going to be sitting here going, hey, whose coffee is this? No one is looking at these 2 cans going, yeah, I don't know. Is it you or is it me? I mean, when we were talking about the sports drinks, the Messi versus Prime versus the world sports drinks, the sports drinks all look a lot more similar than these 2 do. The sports drinks are all real similar. So, trademark infringement, false designation of origin, like a consumer might go buy a Death Wish and be like, I thought this was Liquid Death, or buys a Liquid Death and is like, I thought this was Death Wish. Determination of non-registrability. So they're asking the court to block the Deathachino and to block Liquid Death in the category of coffee. So they are telling the trademark office, or they are asking the court to tell the trademark office to block the new registrations. Do not register Liquid Death in the category of coffees. Do not register Deathachino, etc. So they're trying to block their registration. They're asking for a declaratory judgment. Your Honor, tell us we're right. Unfair competition. Your Honor, they're going to destroy all of our hard work. No. And then their prayer for relief. Your Honor, make them stop it. Mom, mommy, mama, mother. Tell them to stop deathing at us. Prayer for relief. Preliminary and permanently enjoin defendant from using any version of the infringing marks and any other death formative mark or any other mark that infringes plaintiff's right to the death wish marks in connection with the sale, offering for sale, advertising, or marketing of any coffee or coffee-related products in the United States. You can't also just trademark the word death, which is why it is Death Wish or Liquid Death marks. You cannot just trademark the word death. They want to award plaintiffs reasonable attorney's fees and costs. Declare, Your Honor, I do declare that the unauthorized use of the infringing marks or any other death formative mark in connection with the sale, marketing, or distribution infringes. Don't allow them to register the Liquid Death in the space of coffee and Deathachino. Award plaintiff damages for the willful and intentional unfair competition. Just because you hate it doesn't mean it's unfair. Award such other further relief as the court deems lawful. From the lawyers, we got to go find those letters. Death Wish responded a bit. And we're going to pull that up and then I'm going to go look for those letters, because Death Wish did post this. I actually saw this based on the social media post. I don't know if we're going to get to Trader Joe's today. We might have to zoom because we have lots to talk about. What time is it? We got a little bit of time. Emily, we added in Ron and you thought the show was going to run the same runtime? Fail. It absolutely was not. All right, let's pull this up real quick because I thought the response on social was funny. You know, I enjoy a funny response. Ultimately, in cases like this, when brands are fussing at each other on social media, I do not have the same advice as when it is individuals. When individuals are involved in a lawsuit, do not talk about it on social is generally the way that I see things going. Like, it is a bad idea. It is not going to go well. Don't do that. When it is brands fussing with each other, I am much less pressed because A, they have in-house counsel that they're running these things by. B, they have entire social media teams. And C, it's unlikely to hurt their lawsuit. The same rules do not apply for individuals. Give me 1 second while I have to log in so I can pull this up, which is annoying, but it is what it is. So Couldn't see my number pad. So when I say that individuals should not be going after each other on social media or talking about their lawsuits, I stand by that. Brands, I am sometimes occasionally swayed by a cheeky social media marketing campaign. You know, I love some good marketing. It is why I was so, even though I thought that the Aldi marketing in the Colin Cuthbert on social media was cheeky, they were still in the wrong on that case. And both can be true. You can win in court and lose in the court of public opinion. And brands that do a good job in the court of public opinion can genuinely find some brand awareness that others might not have heard of that is delightful. That doesn't generally go as well for individuals. So let us pull up this post.
Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious.
All right. This post is from October 9th. This is posted from Liquid Death's official Instagram account. Death Wish Coffee LLC versus Liquid Death. That's the lawsuit we just looked at. No, we're going to read it. We're going to read it. Liquid Death added them, like full chest added them. Death Wish Coffee and its lawyers have filed a lawsuit in an attempt to stop Liquid Death from ever launching our own coffee brand. But we have no real plans to actually launch a coffee. Here's the thing. What is the Deathachino? Is it a coffee? Because your lawyers told them, like, are we bullshitting? Because your lawyers said that you had pre-made coffee drinks coming to market. So you filed for Deathachino that seems to be a canned coffee drink. Your lawyers said we have a canned coffee drink. So does a coffee flavored drink not count as a coffee? Maybe because it's not beans? Is that where we're at? Like, if they're not beans, it's not coffee? You guys let me know what you think. Because we truly don't know exactly what the product is. Oh, we're going to need those letters. Because I don't know if that's true. But we have no real plans to actually launch a coffee. Then what is the Deathachino? Perhaps the executives at Death Wish Coffee are amped up on too much caffeine to be this paranoid about the future. Which is why the new CEO at Death Wish, and they name him Steve Gardner, may want to consider trying our new Better For You energy drink coming in January. It has 0 sugar, 5 calories, essential vitamins, and a sane level of caffeine. And whether or not we ever go into coffee one day, we don't believe any one company can legally own the word death, regardless of how it's used. And since Death Wish publicly filed their lawsuit against a Liquid Death product that doesn't exist, feel free to let them know on their socials whether or not you support their case. I don't love that. I don't love the brigading. Go tell them they suck. I don't love it. I like the shade. I don't love the brigading. And be sure to listen to some of the great bands like Converge on at Death Wish Inc., the iconic hardcore record label that has been around for over 25 years, long before the coffee brand Skull Emoji Eggplant. Skull Emoji Eggplant. Yes, I commented. I commented a week ago. So it's food court then. I did. The eggplant emoji is funny. Black Rifle Coffee responded. Black Rifle's like, hey, what's up? When I responded a week ago, I was like, this needs to go on food court, and I wanted to make sure I didn't forget to come back to it. Bones Coffee Company made a fake Liquid Death can that says Liquid Death Mountain Water FAFO blend. Then again, somebody said, remember when you all filed a cease and desist against a metal record label for using a skull? I'm curious about that. Other accounts said random idea, you guys should make a coffee. E-Bombs World said, hey, is it cool if we make a water? It's just, Bones Coffee Company also responded with, someone's bitter, or maybe that's just your coffee, which is kind of funny. Brooklyn Dom. One is definitely a very different account than the other. Should Death Wish Skateboards send Death Wish Coffee a cease and desist now? So there are lots of comments on social media. Somebody said can't copyright the inevitable. It's a trademark suit, but we'll let it go. So, you guys are it. I see you responding on Instagram in real time. So, food court. It is Liquid Death Food Court. But the FAFO brand of coffee is actually pretty funny. I don't necessarily believe that Liquid Death has, I think it's a funny response, but I don't believe that Liquid Death has no intention of making a coffee because they filed that they are going to. But for those of you that know Liquid Death, some of you may know Liquid Death from this marketing campaign that I thought was really funny. I thought it was really funny. Do we have sound? Hold on.
You drinking. I've had so many of these today. I wish they would make a huge keg.
Yep. They made kegs for pregs. They made this. Look, I'm not mad at this social media marketing.
Liquid Death is taking my favorite water from actual mountains and putting...
I'm not mad. The kegs for pregs is hilarious. It's really funny.
Oh my God, your water just broke. Whoopsies.
Look, that's a funny marketing campaign. It's a funny marketing campaign. It's really a hilarious campaign for water.
Been drinking for two.
I've been drinking for two is really funny. I'm here for the kegs for pregs. I think it's hilarious. So, look, I'm all for a really funny social media marketing campaign. I love the campaign with Kylie Kelsey. I'm here for it. It's so freaking funny. For those of you, I didn't have the volume on at the beginning. Hold on. We'll play the beginning again. I know. Emily, we're just sponsored? Nope. Just love a good social media campaign. Look. It's funny. Or at least I think it's funny.
Kylie Kelsey, are you drinking? I've had so many of these today.
Yeah, you're just going to have to pee.
Make a huge keg.
It's funny. Look, I don't hate the marketing. That is so loud. I do hate how loud that is. It's funny. Look. The judge drinking on the job is really funny. It's funny. The water ads are cheeky. I don't think anyone's going to confuse this with Death Wish. Their marketing is different. So, this is from 37 weeks ago. Big game commercial. We spent millions of dollars just to make you smile. At least, the least you can do is give it a watch and pretend you love it. It's funny. So, I don't hate it. So, are they going to be in court for a while? Yeah, unless they can figure it out. Also, I need to know what those letters say. So I got to go to Pacer and grab it. But yeah, for those of you that love cheeky internet marketing, we need to see what this one is. Hold on. This is why I think Death Wish Coffee is concerned. I don't know if their social media is the same. I don't know. So I think Death Wish is worried about the takeover in their space. They do have to protect their intellectual property rights. I just don't know how far it's going to go. It would have been funnier. It would have been funnier if they collabed. So this is, I need to know what this post is. I'm curious. So we're going to we'll pull up the letters in a second. I need to know what this is. Wait, damn it. Oh, it's when they made the littler cans. That's right. The size matters. I had forgotten they did this. Okay, fair enough. Hold on. We're going to restart the ad because I had put the volume down because the Kegs for Pregs song was so loud. It was funny, but it was very loud. So we need to try this one more time because it was muted. Emily, you're fighting with Instagram. Look, it's better than me trying to fight with freaking TikTok. All right, let's try it again. I prefer smaller ones.
Not like micro ones, but small ones.
I'm no size queen. I like them small.
The big ones always make me feel like I have to pee.
I made fun of my buddy for having a small one, but then he let me hold it. Now I low-key want a small one too.
I've never had one at all, but if I did, it would be a small one.
Oh my
When I'm
God.
drunk, I want a big one, but only when I'm drunk.
My husband's really into big ones. Kind of weirds me out. So I just sit in a chair and watch him and his buddies just go to town. Meanwhile, I'm just over here enjoying a small one.
The cucumber, though.
Now we have small ones.
Look. There is no way that anyone is confusing this brand. There's no confusion. The marketing team is like, we know who we are, and we're going to tell you. Also, the big ones are the only options at concerts. But I do kind of love that they sell the small ones to take home. You know, sometimes you don't want to take home the big ones. The fact that Tank Sinatra commented, the big ones are intimidating, if we're being honest, is sending me. But the marketing is so funny and it's so on brand for them. And look, instead of small boys, you can now have, your 12-ounce can. It's hilarious. But it's also incredibly different than Death Wish's marketing. Do you see why Death Wish is intimidated? I can see why Death Wish is intimidated. So, you can get a Kegs for Pregs. You can get a big one. You can get a small one. You can decide. It's a funny ass ad. So, we will see where this lawsuit goes. I bet that the marketing on the Death Wish side is not going to be as funny as the Liquid Death side. I'm calling that now. But we'll see. It may be, it may not be. What I do know is that, my family really does like the Dr. Death Killer Cola water quite a lot. The advertising is funny and the branding is good. And I do enjoy the water, especially when you're at a concert. I love having a drink at a concert. I don't always need an alcoholic drink at a concert. So having a can of water is something I very much enjoy. So we'll see where this goes. But I'm not sure that this one is going to get very far because I think the brands are distinguishable enough. I have no idea what the possum is doing. But the Dr. Death is really good. Truly. The Liquid Death breathalyzer, funny. It's funny. It's funny. Their marketing is funny. I'm not mad at it. So, we got to go find the letter. Aaron says they just want to say dead to rights. They really did. They really did. I need to go to Pacer and pull up the lawyer letters that were exhibitees that somehow missed my fingers when I was pulling stuff up yesterday because I don't know how I missed that. I'm like, what happened? I don't know. You don't know. But there's exhibitees and we need them. Normally they are attached when you grab the case. Hold on. Let me pull the case number real quick because that's the only way this is going to work quickly. and we'll pull the letters because I'm invested. I'm just invested. I want to see what the lawyer letters say because, well, we were pontificating. Hopefully they're not sealed. So sorry, lawyers, will we hang out for a moment and grab our lawyer letters together? Like, where are our exhibitees? And why were they not all just filed with the docket? Did they get their own docket number? Yeah. Let's see. Oh, that's how I missed them. All right, well, let's go grab those real quick. Let's grab Exhibit 1 and Exhibit 2 and read the emails because I 100% want to read the emails. You want to read the emails. I want to read the emails. We all want to read the emails. Let me download these real quick and then we will pull them up. There's Exhibit 1. There's Exhibit 2. Pacer. This is what I get when I prep at night. This is exactly what I get. Let's see. Daniel asked, do they have decaffeinated drinks? That's funny. Maybe the coffee will be decaffeinated because, well, they are releasing energy drinks and maybe truly, maybe the Deathachino is like a coffee flavored energy drink. Who knows? I don't know. And they say in their social media post, we are not launching coffee, but the lawyer letters say, hey, we're coming for you. So I really do want to see what the letters say. Let me put these into, why won't it be simple? Just cooperate with me. We needed to put them in the file so we can pull them up. All right. Letters, just go here and hang out so we want to read the exhibitees. Let us read the lawyer emails. It's all we want in life. I work 10 hours and all I want is lawyers, you suck letters, in-house counsel going back and forth, taking jabs at each other because, well, it's funny. The lawyer letters are something I'm very curious about. And now we have them. Yay, us law nerds. Look at us. We hung out. We don't have a death wish about it. Uh-oh. Death wish is going to come for me. I've got skull and crossbones. This one has a lower jaw, though. The other one only had the upper maxilla. This skull has a lower maxillary. The death wish skull and crossbones only has the upper maxilla. Oh, y'all. We need to go grab the spicy skull so they can get mad about the spicy skull because there's more to be mad about, apparently. Letter number 1, Mandible. Dr. B would just be like, Emily, what are you saying? It's fine. I do not have a death wish for the death match. I just want to see funny marketing. I'm here for the marketing. That's it. I'm here for the marketing. Braun, Heggie, and Borden, LLP, reached out to Mike and counsel Tiffany, all at Liquid Death, with the picture of the Death Wish Coffee Company logo, which is, again, a very specific logo that looks nothing like the Liquid Death branding, in my opinion. You guys let me know. Dear Mr. Cicero, Miss Lee, I think I pronounced that correctly, Cicero, greetings. We are Trademark Counsel for Death Wish Coffee, the folks brewing strong coffee and cheating death since 2011. Always with the, hey, we're great. We write regarding your company, Supplying Demand Inc., DBA Liquid Death, and its recent innovation. No. Invasion. Sorry, my brain has stopped. Of Liquid Death by seeking to register USPTO trademarks for Liquid Death and Liquid Death Deathachino in the same coffee market. Same coffee product categories, using the same formative name, Death, as Death Wish. And yes, those are all in italics. These infringing applications, and then they list the numbers, were filed earlier this year and are awaiting review. In them, you assert under penalty of perjury a near-term interest in launching Liquid Death coffee drinks. I drink a coffee drink. I drink a water drink. i.e., in competition with Death Wish coffee. You must have a death wish to try to compete with us. Heather said, so they own the word death? They don't. You can't. They have registered trademarks for Death Wish Coffee Company. Their full trademark is Death Wish Coffee Company. And Liquid Deaths is Liquid Death and Deathachino and Liquid Death, Deathachino, and the rest of it. They say that Liquid Death and its many marketing executives and staff, they're busy making dick jokes, counsel. They don't have time. The many marketing executives and staff have been acutely aware of Death Wish Coffee for years. The brands have engaged in playful banter. You guys flirted with us on social media. How dare you? How dare you try to become us? The brands have engaged in playful banter on social media. Nonetheless, you appear to have embarked on an overt invasion of our... I'm sorry. I'm sorry. I can't. You appear to have embarked on an overt invasion of our client's property, not unlike the masked men terrorizing Charles Bronson's home and family in the original Death Wish movie. What is happening? At least there's a sense of humor. Oh my God. Not unlike the masked men terrorizing Charles Bronson's home and family in the original Death Wish movie. Counsel. What? Also, did you name your coffee after somebody else's intellectual property, the movie Death Wish? Have you ever sued Death Note? What about Death Becomes Her? I got questions. It goes on to say, to wit, if you have to explain the joke, it's not funny. To wit, Liquid Death's infringing applications seek to directly encroach and trespass on Death Wish's longstanding intellectual property to willfully swamp, damn it, bury, to willfully bury. You were doing so well. Stick with the death puns. It was funnier. To willfully bury and damage our clients' brands and to undermine and confuse the market. Just like Bronson, our client isn't taking the assault lightly. Okay. Does it end? It's got to end with govern yourself accordingly, right? Our client isn't taking the assault lightly and intend to spare no expense to ensure the protection of their property. Needless to say, if Liquid Death's home and goodwill were being invaded, you would react precisely the same. What would happen if it was you? Oh my God. What? If, for example, our client were to launch Death Wish Water, okay. Accordingly, in lieu of seeking immediate injunctive and other relief, Death Wish is requesting that you responsibly address its concern by A, withdrawing your infringing applications, B, confirming in writing that you will not launch any coffee product using death formative marks or branding. Absent assurances, our client will have no choice but to seek immediate injunctive and other relief to enjoin Liquid Death's intent to willfully infringe on Death Wish's property. Background. Silent Rage 5 said, what are the chances this is all a PR stunt? I think that Liquid Death will be cheeky with the marketing, but this was not filed for PR. They are they are saying, hey, we think you getting into the coffee market is going to damage our mark. They are saying we're defending our trademark. This is not PR for, or at least probably not good PR for Death Wish. Liquid Death's marketing team will turn it into PR for them, but it was not filed with that intent. This is, hey, get out of our market. This kind of stuff happens. These kind of letters happen all the time, but it is just a, ugh. But the hyperbole is, what movie are we even referencing? Can somebody tell me what year that movie came out? I've never even heard of the movie that they're referencing, which is rare for me. But absent assurances, our client will have no choice but to seek immediate injunctive relief to stop you. 2000. How did I miss that? Law school. Law school? I don't know. Some of you are saying 70s, 80s. We have a wide range of years on that movie. Background. Just in case you don't know who we are. You're obsessed with us, but just in case you don't know who we are. Death Wish has been roasting high-octane, death-defying coffee since 2011. Y'all, if I drink Death Wish coffee, when I die, will one of you just sue them for not defying death? Please? Because I feel like they're just, if Red Bull can't give you wings, can the coffee really help you defy death? I think 5 out of 5 doctors agree that coffee does not, in this way, help you defy death. Chat. We good? Cool. I don't think it's death-defying. I think that's a bit of marketing hyperbole, but they've been roasting high-octane, death-defying coffee since 2011. I think unless you have like a heart condition, and then it's probably death-exaggerating, but that's because it's high-octane. It has a legendary reputation and loyal following among caffeine enthusiasts across all 50 states and beyond. It is one of the top-selling premium coffee brands in America, is sold in ready-to-drink and other formats, and is distributed in thousands of major retailers, grocers, convenience stores, and other outlets. The same locations which you sell your Liquid Death water products. Oh no, we're all in Target. Death Wish protects its products and goodwill. It is repeatedly and successfully sued and enjoined infringers and owns numerous trademarks. Look at our trademarks. Look at our trademarks. They're so pretty. Admire our trademarks. What is the Ginger Dead? Is it like a gingerbread coffee? Is it a tea? I have questions. Death Wish's success in protecting its brand. Look at what we have done. Death Wish protects its brand and has deep sixth. God damn it. Counsel. Really? Murder. You should have said murdered the infringers. Just like you murder your thirst. Oh, wait a second. That's Liquid Death's marketing. We have deep sixed many infringers who have tried to enter the coffee space under death-formative marks. For example, Death Wish has obtained multiple federal court injunctions surrounding the death knell for sounding the death knell for infringement. Stop it! We have deep sixed the infringers and sounded the death knell. Oh my God. And yet you say swamp, not berry? How do we pick when to be sassy and when not to be sassy? I don't understand the choices being made. Oh my God. Federal court injunctions against death formative marks. No death for you. Death before decaf. Order permanently enjoining defendant from using the mark death before decaf or any other trademark, tagline, brand, trade name, or other mark, including the term death in connection with coffee. Death Wish Coffee versus Death Before Decaf 2023. Death Hell Coffee. Death. Order permanently enjoining defendant from using Death Hell Coffee mark and Death Hell Coffee logo or Death Hell Coffee packaging in connection with the sale or offer for sale of coffee or coffee beans. Death Wish Coffee versus Death Hell Coffee, 2024. Death Wish has also blocked the registration of numerous death-formative brands. Triple Death Coffee was not allowed to brand. Death Wish Burritos. What the fuck you got against burritos? But again, Death Wish is too close. Death Wish is too close. I understand the Death Wish burritos because it does say Death Wish. You can't do that. And Death Wish discs. Frisbee? Maybe? All I want is Wingstop. They have also taken enforcement action against death-formative marks. They all are using Death Wish. Your brand is Death Wish. Death Wish Dark Roast, Death Wish Lip Balm, Death Wish Deadlifts. And then Death Coffee and Death Wish Cafe have been removed. You intend to infringe. Liquid Death launched in 2019, more than 8 years after Death Wish and its proprietary coffee products. They then say, Liquid Death has done well. Kudos. Oh my God. You guys are so cute. Good job, you and your little water market. Adorbs. Look at how fun you are. Yay. The two brands have coexisted peacefully because they operate in wholly different market areas. One sells coffee, the other sells sparkling water. The situation has even produced friendly ribbing on social media. Look, our tweet was funny. Don't you love our tweet? Look at our tweet. We're cute. The one. As Liquid Death acknowledges above, the reason why Death Wish and Liquid Death have been able to coexist is because Liquid Death is water, not coffee, and vice versa. That seems to be changing. Liquid Death is gearing up to invade our client's home property. Not the same. No. It recently filed 4 trademark applications, 2 for Liquid Death coffee and coffee-flavored beverages, and 2 for Liquid Death Deathachino, also coffee products. These are intent-to-use applications. They go on and note the pattern that we talked about before. And then we get to the demand. Our client will do anything. Anything. Our client will do anything to defend its territory and hopes this dispute can be resolved constructively so that both parties focus on selling products in their respective markets without interference. Please confirm by no later than August 8th, 2025, that you will accede to Death Wish's aforementioned legal demands, namely to withdraw the infringing applications and confirm it will not launch any coffee products using a death-formative mark or branding. Otherwise, it's time for Death Wish to rechannel Bronson? What? Literally, we'll kill you. Ron was less threatened by this and went to the judge to complain about it. We will do anything for coffee. Well, the letters do not disappoint. The letters do not disappoint. While this dispute remains pending, please also confirm in writing that Liquid Death and its agents and representatives, including outside advertising and marketing agencies, place an immediate litigation hold on forensically preserve all digital and hard copy documents and media, including emails, texts, and other digital messaging, business and accounting records, sales and marketing related in any way to this dispute. So it's a, don't delete your shit demand. Related in any way to this dispute, including without limitation, documents related to its planned launch of beverages in the coffee market, its selection of its death-formative trademarks, and its knowledge of Death Wish's brand and rights. We look forward to your response. All rights reserved. Very truly yours, J. Noah. Oh my God. Don't make us go all Bronson on you. It's just so extra. I mean, we love a little extra. It's why we do food court. This is exactly why we do food court, because it's so extra. Like, what are we doing? You have assaulted us in this analogy that we have created about a movie. What? Well, what time is it? Oh, we are going to run out of room for food court. I said I would do both. And then this ended up taking way longer than I anticipated. We will zoom quickly through the Trader Joe's one. It's not as funny as this. Because we have to talk about, well, we have to save a little time to talk about Canton, Massachusetts. So I know you will forgive me. We've needed a food court. Let us continue. It'll be fine. Look, the Trader Joe's ones isn't as funny. This one is definitely funnier. So Exhibit 2 is the response, I think. Let's find out together, shall we? This way. All right. Via email, September 30th, 2025, regarding Liquid Death's infringement of Death Wish trademarks. Dear Sir, as you know, we serve as outside litigation counsel for Death Wish Coffee. We are in receipt of your September 5th response. Did they not attach it? No. Darn it. They didn't attach the responses. They only attached their responses. Boo! Give us all the emails. We want emails. Boo! As you know, we serve as outside litigation counsel for Death Wish Coffee. We are in receipt of your September 5th response to Death Wish's July 29th demand letter regarding Supplying Demand Inc., SDI, which is Liquid Death's, infringing plans to launch Death-branded coffee products. Your letter indicates you intend to proceed with its plan to invade Death Wish's marks with forthcoming coffee products. Your letter further admits, Your letter further admits that the infringing coffee products will appear side by side with Death Wish's products in the same retail and marketing channels, leading them to compete on the shelf. Thus, picture. So if you're listening in the background, picture. Thus, death confusion. Oh no, I'm wearing skeletons while I'm talking about this. Oh no. We urge Liquid Death to abandon this folly. The fuck? Come on, counsel. Where's the we warn that Liquid Death is taking their life into their own hands? Go harder. It feels like folly is halvesies. We urge Liquid Death to abandon this folly. Its intended Liquid Death branded coffee products will confuse consumers, infringe on Death Wish's marks, and irreparably harm Death Wish's brand and business. Your letter attempts to nitpick Liquid Death's claims with a variety of arguments, none of them serious or legally cognizable. You're telling me they responded to your letter likening their trademark applications to a movie series and Bronson's house, and you said that their response was not serious? They were just following up on your tone. Counsel, how dare you not be serious? First, Liquid Death asserts that the party's products will not be confusingly similar because they will include additional words other than death on the label or other design elements. This is a crazy argument. Oh my God. Seriously? Look at the font they picked. The bold italices. This is a crazy argument. Oh my God. This is a crazy argument, which we presume Liquid Death's actual ownership and management have not endorsed. Do your bosses know that you made this argument? Counsel, does the ownership of Liquid Death know what you're saying? Does management know what you're saying? I need your manager. Excuse me, Liquid Death? Where's your manager? Because I can't imagine that they would endorse your crazy ass argument. Don't make us tell your boss. In-house counsel has to be like, you got to be fucking joking me. For example, does your client actually admit it would readily invite dozens of sparkling water competitors to invade Liquid Death's brand rights by adding other words to the product? We can think of a few that might catch on. No. We can think of a few that might catch on. Hard Death sparkling water, water of deathly delight, death trap water, death defying sparkling water. It doesn't go hard enough, counsel. If you're like, look, we could do water too, it's got to go harder. Picking just a different font from Canva isn't going to make it happen. Like, stop trying to make fetch happen. Would your client like another water company? Like Hard Death? They would be like, nah, it's too little to really make the hard pun. So our bosses are less than impressed with your flaccid attempt. So death trap water. Oh my God. Thankfully, the law is clear that by simply adding non-formative words to a mark does not reduce the likelihood of confusion, i.e., because similarities weigh more heavily than differences. C.E.G. Palm Wonderful versus Hubbard, 2014, granting a preliminary injunction against infringing beverage product despite alleged visual differences in the packaging. This is why courts for decades have held shared use of a dominant element like death is sufficient on its own to show competing marks are confusingly similar. C.E.G. Galileo Winery versus Galileo Cattle Company. Affirming injunction against the use of Galileo combined with other word, like cheese or cattle, because they shared the dominant element of Galileo. Galileo, 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 Galileo Figaro. Magnifico. I can't even today. I can't. How did we get here? Oh, I'm sorry, Galileo Winery. Yeah. Okay. I don't think it's the same, but apparently you weren't allowed to have Galileo cattle because it might get confused with Galileo Winery. But alas, continuing on here, there is no question death is the dominant element of Liquid Death's products as they are of Death Wish's marks. That is how people in the real world perceive Liquid Death's existing sparkling water trade dress, because that is what SDI's marketing has taught them. And that is how trained brand experts view the brands. For example, Men's Health recently profiled an article of our clients' respective death branded products next to each other. Excuse me. Next to each other based on their identical formative punk rock styles. Counsel, are you fucking joking me? The headline of the article is literally, the biggest thing in health food is death metal. Counsel, really? Fucking hell. They can't even accurately represent the article. Nicole Kearns in the chat said Death Becomes Water is a 10 out of 10. Is a 10 out of 10. Also, they're clearly referencing death metal and not punk rock. What in the ever-loving fuck, counsel? Of course, you can't tell the difference between water and coffee if you can't tell the difference between death metal and punk rock. For real. The subheadline of the Men's Health article says, Death Wish, Liquid Death, Misery, and Mayhem. Doom food brands want to know. Are you ready to rock? You mess with the bull, you get the horns. But Men's Health said it was punk rock inspired. They literally fucking say death metal, but whatever. Emily, you got to let it go. I can't. It makes me angry. They're not done yet. Next, bold and italices. Next, Liquid Death makes a crowded field defense, which is also dead on arrival. That one works. That DOA works. Your letter asserts that, quote, the beverage field is crowded with death-formative marks. But then your letter tellingly fails to cite a single example of anyone other than Death Wish using a death-formative mark for coffee on any significant scale. Oh, so they're just not big enough. Instead, you cite a handful of pending applications and registrations with the USPTO. But as you know, there is a difference between registration and use of a mark, and registrations alone say nothing about the existence or non-existence of a crowded field. Further, the reason no crowded field exists is because Death Wish has been diligently murdering the competition. It's not what it says. Death Wish has been diligently and overwhelmingly successful in enforcing its rights against infringing marks. It's not a crowded field because if they use the word death, we swoop down on them like the Reaper. That's why. Your letter dismisses these efforts because many infringers immediately were forced to abandon their infringement rather than taking the matter to trial. Yeah, they're small brands and they went, fuck, we don't have the money to fight with you. So it is your practice and habit to send out letters saying, we're going to go full Bronson on your ass and we will stop at nothing. And these other brands went, shit, man, fuck. Okay. Death is inevitable, but whatever. They go on to say, your letter dismisses these efforts because many infringers were immediately forced to abandon their infringement rather than take the matter to trial. But the fact that past infringers agreed to cease and desist with infringement to avoid certain defeat is only further evidence of the strength of the Death Wish marks. Death Wish has a 100% enforcement record against death-formative marks in the coffee space. We'll kill you. We'll kill you. Your letter offers no reason to believe the result against Liquid Death will be any different. Last, your letter concedes that Liquid Death is explicitly aware of Death Wish and its trademark rights. You assert, however, that Liquid Death will escape liability for willful infringement because its awareness of Death Wish proves nothing. You know nothing. To the contrary, Liquid Death's knowing adoption of an infringing mark in the faces of Death Wish's superior trademark rights will support an award of enhanced damages, attorney's fees, and punitive damages under the applicable law. Law stated. Additionally, as if to confirm its disrespect, that's verbatim, as if to confirm its disrespect for Death Wish's trademark rights in the coffee space, Liquid Death has begun running advertisements stating that its upcoming energy drink products feel like coffee. And then they have a picture of the advertisement again. At this stage, oh, you're going to tell them what to do, counsel? This is why I hate civil litigation. At this stage, Liquid Death needs to make a decision. unequivocally, it can't be a dramatic reading if you can't talk, Emily. Damn. It was so dramatic, I couldn't even say it. At this stage, Liquid Death needs to make a decision. Unequivocally confirm it will abandon plans to market its Liquid Death products as coffee or face legal action. They chose the latter. Aside from being correct as a matter of law, honoring Death Wish's rights align with your client's professed values and mission. Did you even tell your client you're fighting with us? Even today, Liquid Death's website claims its business was built on an ethos of fair play, using health and humor to conquer the world, and being different from mega corporations. Oh, you mean like Death Wish, who apparently anytime somebody says the word death swoops in with a trademark action? But embarking to steal a pre-existing brand's mark and death territory is not funny. That is their sentence, everybody. Embarking to steal a pre-existing brand's mark and death territory is not funny. Identity theft is not a laughing matter, Jim. It is precisely the kind of big, bad, bully activity which Liquid Death once lamented. And aside from wasting money and reputation, will directly expose Death Wish's own brand and marks to infringement from others who will parrot its admissions that using death, combined with other words, cleanses a competitor of infringement. Please confirm in writing no later than October 6th that SDIA will not launch any coffee beverage using death-formative marks, marketing, or brand name. B, withdraw its infringing trademark applications. And C, not become the kind of corporate thief that it has professed not to be. Oh my God. You guys. How are these lawyers not laughing at themselves? A, B, and C. Not become the kind of corporate thief that is professed not to be. Do better. Donna Turner said, IP paralegal here 35 years. This makes me laugh. I mean, they can't have it both ways. Here's the thing. They're arguing that counsel's not taking it seriously enough, and then they're not taking it seriously. I mean, they are and they're not. Like, what do you want with this? All rights reserved. Very truly yours, J. Noah. The back and forth between it's really not that deep and it's all that deep. And it's just, oh my God. But also, I was not aware of how many other brands Death Wish has been like, nope, death to you. Get in your coffin and go away. But the council seems to be having a good time with the letters. I'm entertained. I mean, I'm really curious to see where this goes. Death Wish is like, no, you shall not have coffee. And Liquid Death is like, okay, we don't have coffee. But the trademarks are in that category. So even though they say on social media, we don't intend to launch a coffee, Deathachino seems coffee related. I'm just going to Liquid Death's website. Their tagline, by the way, is murder your thirst. So I'm curious if it says anything about that on their website, which I don't see. So it's interesting that let's see. This is not an advertisement, nor is it sponsored, but their website has a section called the Time Waster 5000. And like, what in the world is happening? What? Liquid Death X Spinal Tap. There's videos. Oh, the little one's marketing. Toxic Avenger is our new spokesperson. Well, that's a deep cut that Toxie is the spokesperson for Liquid Death. Chainsaw sliced sandwiches. Get your real sandwich sliced by a real chainsaw at Real Sheets for free. Liquid Death Sweet Reaper Tea. We're the official iced tea of Arizona. Didn't Arizona Tea try to sue them too for one of their tea flavors? Oh, Ozzy. Infinitely recyclable Ozzy. Ozzy Osbourne is one of one, but we're selling his actual DNA so you can recycle him forever. I don't even know what's happening. Our moms test Deathberry Inferno. That's actually pretty funny. The marketing is 10 out of 10. 1/10 with Tony Hawk. Liquid Death has 1/10 the sugar of top sodas and 1/10 the body of a top celebrity. Okay. So they've just got all their marketing on. They have a pit diaper. Relieve yourself from the safety of the mosh pit. Powered by Depend. The Liquid Death pit diaper. I mean, I've spent time in the pit. I understand. We talked about the Arnold Palmer versus Armless Palmer, which turned into Dead Billionaire. We did. We talked about it during another food court. We're just going to farm Liquid Death food court. The Yeti X Liquid Death coffin was not something I was expecting. It is a casket cooler. It does kind of look like a Yeti. It can't be real. Hot Fudge Sundae sparkling water. So that's the tie-in with the boys. All right. The Time Waster is just all of their marketing campaigns. They're actually pretty funny. So, Liquid Death is just, well, we'll see. Wait a second. I didn't scroll far enough. I didn't realize there was an e.l.f. makeup Liquid Death collab for corpse paint. That's funny. I don't know what's happening. I understand why this section of their website is the Time Waster 5000. I get it now. There is a music video called Fuck Whoever Started This. They should send that to the lawyers. Just send the music video to the Death Wish lawyers. Because I don't know what's happening. Okay. The Liquid Death Enema of the State kit is not something I had on my bingo card, but there's Travis Barker holding the Enema of the State collectible enema kit by Liquid Death. I've scrolled too far. I've just okay. We've scrolled too far, everybody. We've scrolled too far. We've scrolled too far. We've done it, everybody. We've reached the end of the internet. So, Liquid Death, Death Wish, Death Match. I'm interested to see what the courts think of the Death versus Death, because they are both established brands. But is the death word going to be enough to knock out anyone else in the coffee space using the word death? Carla Berry said, don't you think the diaper was too far? No, actually. But then again, I've been in the pit at concerts and it's real hard to get back and forth. So no, I actually am not mad. I'm not mad about the pit diaper. No. It's kind of funny. There were others, but I am very tempted to play the music videos, and that will definitely be flying too close to the sun. And we still have to talk about Spidey D and Trader Joe's. However, all of the talk of water and the Kegs for Pregs video, I find myself in a place where I am not for usually, which is I have to take a break and use the restroom real quick because, well, I recorded a podcast for an hour this morning before we started streaming, and it is definitely time to take a restroom break. Law nerds, don't go anywhere. We have more to cover because food court is not done. But I have to go to the restroom. It has been a long day. I have to go to the restroom. But I am curious to see where the legal side of this goes. I'm really curious to see where the social media side of this goes because I feel like Liquid Death's marketing has established themselves to really have the cheekier outcome in the marketing side. But it does seem that Death Wish has been pretty successful in keeping anyone using the word death out of the coffee space. Is this the coffee space? Because Liquid Death said, we're not launching a coffee. So is it not? Is it coffee flavored something else? And not actually a coffee? I don't know. But it could be. Rolling Along said Deathachino could be a mocha flavor and not true coffee. It could be. Deathachino could absolutely be coffee flavored product. So that is fair. Did it turn into a not for work stream? Maybe, but not really. We didn't intend for it to be. But when I said I recorded a podcast, I was a guest on other people's podcast. I did not record for us. So I don't know exactly what the product is, but also Liquid Death is like, nah, we're good. Nah, we're good. You should play the video while you're on break. No, Teresa, then I'll come back and the entire thing will get taken down on some kind of crazy copyright claim by somebody else. Terry said, I love food court. Food court is the most fun. It really is. I am going to roll our stream break. I will be right back. We are not going to app ping you because I'm going to go real quick. You will hear the chimes when I am back. So I will be right back. I'm going to run quickly to the bathroom. I might have to go grab, I swear, if my kids took all of the cold Liquid Death out of the fridge, well, I guess we'll find out when I get back. Stay tuned to see if my kids took all of my the cold Liquid Death. I'll see you in just a second. Hello, chat. All right. Thank you. Thank you. Back to food court. I didn't even do a summary. I was like, you guys, I have to go to the bathroom. But look what I found. It's a small one. We had a cold Liquid Death Dr. Death in the fridge. It's Travis's favorite flavor. But let's do a where is my letter opener? We can't harm the nails in opening the can. I do love that the cans are gold on top. It is a different vibe. Let's see if we can summarize what is going on with the Death Wish Liquid Death match over the Death trademark. This is not the same kind of lawsuit that we are seeing in other places that we have covered. This is Death Wish Coffee coming in and saying, death to you. They are saying that this case is dead on arrival. No, they said that this case was a winner dead to rights. Okay, I'm just about done. But Death Wish is saying that Liquid Death has filed trademark requests or trademark applications in the coffee space, and that they are the death forward coffee, and that there shall be no death for you, and that Liquid Death is infringing on their goodwill and their trademark, and highlighted that they have been successful in keeping others out of the coffee market, things like Death Before Decaf and others, because they are confusing. So we will see what Liquid Death does when they respond. I think the funniest part of all of this was the letters back and forth between the lawyers, though the letters from Liquid Death were not included. But on social media, Liquid Death said we had no intention of launching a coffee. They did file trademark applications for Deathachino, Liquid Death Deathachino, but they have also They have also filed trademark applications for things like Liquid Death Mountain Don't, which is presumably one of the flavors like what I have, which is Dr. Death. It is a Dr. Pepper adjacent sparkling water. And they're also launching, apparently in January, energy drinks. So is Deathachino a coffee flavored beverage and not coffee? I don't know. Are these in the same space or adjacent spaces? I guess we will see. But the letters from Death Wish saying, like the movie Death Wish, you are invading our home, I imagine riled in-house counsel enough to be like, oh yeah? And so Liquid Death did respond on social media and say, we had no intention of it. Maybe your new CEO is a bit jittery from your coffee. Maybe you should take it down a notch and try our new energy drinks. So we'll see how much this feud plays out on social media. I think Death Wish also accused Liquid Death of flirting with them and then invading their space. It's like, but you were so nice to us on Twitter that one time. You noticed us in 2022. Why you want to have coffee, man? Come on, we're the death coffee, you're the death water. Stop it. I'm interested to see what happens with this, or if the parties are able to resolve it saying, okay, well, a coffee flavored energy drink is not going to be substantially confusing. But to me, the brand identities are completely different. And if you are looking for a Death Wish product, it is pretty clear the labeling and logoing that Death Wish is Death Wish and Liquid Death is like big dripping skulls. Like it's not the same branding. And I don't think just the word death makes these two brands confusing, but we're going to have to wait and see what the trademark office says and, well, ultimately what the court says. But Death Wish wants to put the nail in the coffin of Liquid Death having a coffee business. And we're going to have to wait and see because this was just newly filed this month. But right in time for Halloween food court. So am I mad? Not at all. I'm not mad at all. I'm not mad at all because it was funny. And as the chat has pointed out, you can't have coffee without water. Like, I'm not mad, man. So, Miguelina, okay, then yes. Okay. Sorry. Answering other questions. Let's talk about Trader Joe's real quick. And then we have to talk about Canton. We're not there yet. Carla Berry, this was a great question in the chat. Carla Berry said, are trademarks country dependent? Yes, they are. And so these are all US trademarks that they are fighting over. But You would need separate trademarks in Canada, separate trademarks in Australia. I am not sure if the EU has to be filed everywhere or if they can just be, if you can trademark in the EU and then other places separately. But yes, they are by location, which is one of the problems US companies have when they are knocked off in other countries, because if they don't have a trademark in that other country, it can become confusing. And a lot of countries use products from the US, but you do have to get trademarks in those other countries. So let's talk about Trader Joe's real quick, and then a little bit about Canton. I know, we got to do it. But there was one other case that I said at the beginning we would talk about. We're going to talk about it briefly. We are not going to get all the way into it. Where is my updated document? Sorry, I got lost in the documents because I was, looking for the rest of the Death Wish stuff. Trader Joe's got sued. How many of you are Trader Joe's fans? Some of you are like, I don't even know a Trader Joe's. What is a Trader Joe's? Look, Trader Joe's has a loyal following generally. I love a Trader Joe's. There are some products you can only get at Trader Joe's. I'm a big fan. I like Trader Joe's. However, we are going to see more of these lawsuits. This is a growing trend. And the copycat lawsuits, there's another one going on with Oreos and one of the chips under the same company umbrella versus Aldi. So the trade dress infringing, copying foods is a growing area of lawsuit because, there are a lot of, what did Bethany Frankel call it? Cheater brands. There are knockoffs, and the food space has a lot of knockoffs. So we know Aldi has been sued over this. We have seen the Cullen and Cuthbert. I also talked about the snow globes. Aldi lost the snow globe battle, where they directly ripped off M&S's gin snow globe bottling in Europe. Copycats is a problem. So, is this a copycat? Is this a cheater brand? Or is this just a good idea? We'll see. But Smucker's is mad at Trader Joe's because Trader Joe's apparently made an Uncrustable. And Smucker's is like, the fuck you did? That's my sandwich. No sandwich for you. This was filed October 13th, 2025. Smucker's Uncrustable sandwiches are the #1 frozen handheld brand in its category in the United States. Footnote 1, reporting data. They have achieved that position through decades of marketing and product development costing over $1 billion. Wasn't there a poll on how many Uncrustable sandwiches each NFL team ate? Uncrustables are definitely one of those things. I know it's one of the things I sent Travis with when he went to training camp for DCI. I was like, here are the Uncrustables. As a direct result of this substantial investment, consumers immediately recognize Uncrustable sandwiches by their unique design features, which are protected by several U.S. trademark registrations as set forth below. In an effort to trade off of Smucker's valuable goodwill and Smucker's substantial investment into valuable IP with Uncrustables, defendant Trader Joe's has launched an obvious copycat advertised for sale at Trader Joe's, shown below. Trader Joe's is selling a crustless peanut butter strawberry jam sandwich. So, Smucker's does not take issue with others in the marketplace selling prepackaged, frozen, thaw-to-eat crustless sandwiches. So why are you mad at Trader Joe's? But it cannot allow others to use Smucker's valuable IP to make sales. Okay. Nikki asked, does Trader Joe's sell Uncrustables in their store? No, Trader Joe's sells Trader Joe's brands. So Trader Joe's does not sell Uncrustables. It cannot allow others to use Smucker's valuable IP to make such sales. As set forth below, defendant's actions constitute trademark infringement, trademark dilution, unfair competition, false designation of origin. I don't think anyone looks at that box from Trader Joe's and goes, oh my God, that's an Uncrustable. They look at it and go, oh my God, that's a Trader Joe's version of an Uncrustable. Okay. Let's see what they say. Tracing its roots back to 1897 in Ohio, plaintiff, the J.M. Smucker Company, is a corporation organized and existing under the laws of the state of Ohio, with its principal place of business at 1 Strawberry Lane, Orrville, Ohio. Its 5th generation of family stewardship, Smucker is proud to offer products that consumers trust for themselves and their families every day. Today, approximately 90% of U.S. households have a product from the Smucker portfolio. That's substantial. Like, it's like, yep, sure. Upon information and belief, Trader Joe's is a company from Monrovia at 800 South Shamrock Avenue. So, jurisdiction and venue. We are not going through jurisdiction and venue. I want to know what the beef is. Well, the beef is peanut butter and jelly, but I want to know what the beef is. What's the Damn it, Emily. We didn't lead into this singing it's peanut butter jelly time. I know we didn't. What's the beef? It's no beef. It's peanut butter jelly time. Peanut butter jelly time. Peanut butter jelly time. Where ya? Where ya? Okay. It's peanut butter jelly time. The famous Uncrustable design mark. For well over a century, the Smucker brand has been helping to make meals and snacks more delicious. Smucker is proud to make great tasting, convenient, and responsibly produced food. For more than 125 years, Smucker's has maintained a commitment to meeting the highest standards of quality for its products. As a result, the general public has come to associate high-quality goods with Smucker and the Smucker's brand. For the last 20 years, Smucker has invested over $1 billion to develop the goodwill associated with its Uncrustable brands. That's just Uncrustable. And the trademark rights in and to the design of a round, crustless sandwich, inclusive of the configuration in a round pie-like shape with distinct peripheral undulating crimping. Oh, is it the crimping? As well as the pictorial representations of a round, crustless sandwich in whole and with a bite taken out of it showing the filling. Okay, an advertising picture with a bite taken out of it is not revolutionary. Florals for spring. I mean, really? Tell me more about the crimping. Since as early as 1996, Smucker, by and through its predecessors, has been using a pie-like shape with distinct peripheral undulating crimping to identify sandwich products. Look, it's an Uncrustable. Woo. They go on to show the pictures. They go on to talk about the trademark registration. Since at least as early as 2000, Smucker has been using two-dimensional pictorial representations of a round, crustless sandwich with the bite taken out of it, showing the filling inside to identify the products as shown. They drew a picture. Woo. Smucker also has rights that date back to at least February 2024 in and to a mark that consists of a round, crustless sandwich representing a body with a crescent shape representing a mouth, and with eyes and eyebrows and arms and legs and shoes to identify a sandwich. I mean, it doesn't seem very on brand for Smucker to be like, eat me, but maybe. And then the Smucker sandwich guy that looks a lot like the I don't know, the Kool-Aid pitcher, but whatever. They have trademark filings in all of those. They also have trademark filings with design marks. So we are in the world of trade dress. They have their advertising, and then they go to talk about why Smucker's Uncrustable have gained popularity. I don't disagree. They say it is particularly helpful to parents preparing lunches, as shown on their website. Uncrustable sandwich require literally zero prep. You just take it out of the freezer in the morning, and it's thawed by lunchtime. Yep. True that. Smucker used the Uncrustable design marks to promote its high-quality sandwich products on its website, social media, and product advertisement, as shown below. Look, website pictures of Uncrustables. The purple ones. Oh, I'm glad it's the purple ones. Yay. And then they've got their Facebook ads. And then they have their social media ads. No dick jokes in any of those ads. I know we've moved on to a different lawsuit. Smucker's is like, how dare you? They say Smucker's Uncrustable sandwiches are sold in thousands of retail stores across the country. Because of the substantial demand and popularity, Uncrustable sandwiches come in multiple flavors and varieties, including peanut butter and grape jelly, peanut butter and strawberry jelly or jam, peanut butter and raspberry, berry burst peanut butter mixed berry, and limited edition PB Cocoa Craze peanut butter and chocolate flavored hazelnut spread. Oh, Nutella would like a word. They have pictures of all of them. Let me know if your favorite one is in here. They have PB Choco Craze, chocolate flavored hazelnut. That actually sounds really good. I've never tried that. Up and apple, bright-eyed berry, and others, including what does this look like? Oh, peanut butter, just a straight up peanut butter sandwich and peanut butter and honey. All right. So, that. All the different Uncrustables. It's a lawsuit. It's an advertisement. It's a sandwich. Look at our website. We devote time and energy. Smucker's devotes a significant amount of time, energy, and resources towards protecting its value of the Uncrustable brand and the products in an effort to yield great rewards. Of course, you protect your brand. As a direct result of significant time and investment, Smucker's Uncrustable branded products have grown over the past 20 years, and Uncrustable products are fast on their way to being a $1 billion brand. I'm sorry, $1 billion brand. Oh, Caddy in the chat said, what the heck is a fluffernutter? Oh, let the Northeast share with you what a fluffernutter is. All of you are like, what the hell is a fluffernutter? Deliciousness. Deliciousness. So Uncrustable, not the Smucker's brand, the Uncrustable branch of the Smucker's brand is on its way to becoming a $1 billion brand. Well, the NFL seems to be buying most of them. Smucker produces approximately 1.5 billion with a B Uncrustable sandwiches annually. 1.5 billion sandwiches. They have 3 manufacturing facilities in Kentucky, Colorado, and Alabama. Uncrustable sandwiches are recognized and enjoyed everywhere from school cafeterias to the NFL. Footnote 2. See the story. Wait, NFL players eat how many Uncrustables? The fact that I know about this media story is hilarious to me. The fact that it's in here. Oh no. Hold on. God damn it. Paywall. I didn't hit open a new tab. Let me get back to our lawsuit. Also, I don't have an account. It was a story about NFL players eat lots of Uncrustables. And they were arguing by team who ate the most Uncrustables. That's the punchline. We're not going down the rabbit hole behind a paywall. The fame and popularity of Uncrustable sandwiches and the Uncrustables design marks is not without cost, as evidenced by the number of copycats that have tried to enter the marketplace and trade off Smucker's substantial investment, including defendant. In connection with the back-to-school product offerings of late summer, and in an obvious attempt to trade off the fame and recognition of the Uncrustable design marks, defendant recently introduced a round, crustless sandwich with a crimped edge that defendant is marketing with a bite taken out of it on the packaging that mimics the Uncrustable design marks, as shown in photographs below. Well, on this one, the bite taken out of it is facing you, and on the other ones, the bite taken out of it is facing a different direction. As dupes go, this is not as directly duped as some of the other ones. The marketing is not exactly duped, but yes, it is a round-ish. It's like Squoval. It is not as round. It is more of a Squoval shaped, but yes, it has some types of crimped edges. So it is too round, apparently. It is. If it were more square, we might not be here, but it seems that the bite out of the side is really pissing them off. They go on to say that, but out of all of the colors that could be chosen, I am reading this verbatim. But out of all of the colors that could be chosen, defendant chose packaging that prominently features the same blue that Smucker's uses and has trademark rights in, as shown in part, trademark registration number 7799903, covering the word Uncrustables in blue stylized letters. Is it cerulean? That blue. The Uncrustables blue. So, they used the Uncrustables blue for their box. Now, the other words are in peanut butter brown, strawberry jam red, and purple, or navy blue. I can't really see. But they have used our blue. Yes, people trademark colors. Yes, Tiffany blue is a thing. Yes, Disney has a go away green and like a bye-bye blue. People have blue and other colors, not just I'm blue, but other colors that are trademarked and are significant to their brands. But I have no idea exactly what the Uncrustable blue is. But they say that their Uncrustable blue is being used by Trader Joe's. Smucker's writes in and to the color blue in connection with the sandwich products as shown in Exhibits E and F are valid and have not been licensed to defendant for use. Trader Joe's didn't even ask us to use our blue. These are fights that happen all the time. There were a whole bunch of fights over whether or not you can put red on the sole of a shoe. Ask Louboutin. So, they go on to say there are many other commercially viable ways to offer a competitive product without mimicking, copying, or otherwise trading upon the goodwill associated with Smucker's Uncrustable designs or using packaging that mimics the colors Smucker's uses. And then they post somebody on social media who probably had no idea they were going to be posted. And it says, not surprisingly, because of defendants' use of the infringing marks and infringing trade dress, members of the consuming public have already been deceived into believing that defendants' product is in some way sponsored by, originates from, or is affiliated with Smucker's, when in fact, it is not. And then there is a social media post that says these aren't knockoffs. Trader Joe's contracts with the companies to make the Trader Joe's labeled items even when they're the same thing. So they're trying to say that Trader Joe's is white labeling Uncrustables from the same manufacturing facilities and then labeling them. Okay. So the public is confused because someone posted on TikTok that these are Trader Joe's branded Uncrustables from the same Uncrustables. Okay. Sure. They posted somebody else's video about Trader Joe's and they hashtagged it, hashtag Trader Joe's, hashtag Uncrustables. They go on to say in a recent article appearing on Yahoo, the author made specific mention of the confusion and deception arising out of defendants' unlawful use of the Uncrustable design marks, noting, quote, the Trader Joe's version was initially the most deceptive because of its shape. Like Uncrustables, the snack is round with a crimped edge. This confusion was not a surprise given defendant's prominent use of the Uncrustable design marks. Moreover, defendant willfully exacerbates the confusion by A, minimizing the reference to Trader Joe's on the carton, using a smaller font and muted color compared to the surrounding text, and B, omitting the reference to Trader Joe's entirely from the individual product wrapper itself. Defendant's conduct was willing, knowing, intentional, and contrary to law. You can't have our sandwich. No sandwich for you. So, claims for trademark infringement. We will see what Trader Joe's has to say. They have not responded yet. They are asking that Trader Joe's be stopped from continuing to use the infringing marks, which could be everything from changing the shape of the sandwich to using a different color packaging or licensing the color from Smucker's. So, Smucker's versus Trader Joe's. We will see. But is there confusion in designation of origin because people on the internet are saying they come from the same facility? I don't know. But we will see. Because you know what? Food court is never boring. Food court is never boring. You know what else isn't boring? Clever marketing. Before we get to my internet beef, we have to talk about Canton. Because I learned something yesterday that I did not know. Emily, you have too many tabs open. I do. But we have to move on to talk about Canton real quick. Because as I was thinking about cheeky marketing, I was looking at what we were going to talk about today. And we definitely have to talk about the fact that Spidey D has been apparently falsely imprisoned, but maybe it's not false imprisonment. I have questions. We're going to have to talk about Spidey D. And so as I was trying to figure out how Spidey D ended up in prison, because it seems that Spidey D has now been placed in prison, I stumbled across this, which I was not aware of. For those of you that are not aware of Spidey D, A, last year's food court, we got down this rabbit hole. B, we love Spidey D. We love Spidey D. It's cheeky marketing. I think it's hilarious. I love cheeky marketing. I do have beef, but we will get there. I think we have to go back to purple if we're going to talk about Spidey D. Because we were definitely using the purple lights before Spidey D popped on the scene last year and started using the purple. So let us shift the lights back to the purpley-ish lights. The ones in the back didn't want to go. They were like, no, we're not going purple. Really? You're going to fight with me? Oh. The lights in the back are like, no, we don't know you. We're not doing what you want to do. Really? We're just not gonna comply? Sure. Rude. Hey, 30 seconds. We're gonna make the lights comply real quick. It's going to happen. Maybe. There we go. All right. Thank you, bookcase, for complying. We had to go back to a little bit of purple because we have to talk about Spidey D. So as I was, doing a little bit of my research, I came across this interesting article that highlighted information I was unaware of. For those of you new to Spidey D, you might need headphones because of their social media marketing campaign. There were times that my kid was just like, wait, what? Spidey D was rehomed with Chloe. It seems like it. Some of you are saying that you are having audio issues in chat. Restart your YouTube. because our feed health looks great and it's just a very, very few. So I would restart on your end the YouTube things. Let's continue talking about Spidey D. All right. It has shifted just ever so much. No. I'm in charge now. We're going to have to just go this way. I'm in charge now. Why Dunkin's viral Spidey D ad campaign is the future of marketing. I sure hope so, because it's fucking funny. How a spooky season spider donut took over the web. Some of this was from last year. Yes, this is an actual post from Dunkin. All of these are actual posts. Yes, the post, I got the long legs, all I need is the daddy. That was from last year. Up in the corner, the she ghosting you, but she gobbling me. That was from this year. It's silly. It's sassy. It can't spell too good. But Dunkin's Spidey D donut campaign may soon enter the canon of Canton-based companies' most memorable marketing moments. How in the ever-living fuck was I not aware that Dunkin originated in Canton? How did I not know this? How did I not know? The Dunkin' Spidey D donut campaign may soon enter the canon of the Canton-based company's most memorable marketing moments. What? Canton is Dunkin'. Dunkin' is Canton. How did I not know? I was completely unaware. But we need Spidey D to go figure out the Proctor problems. Spidey D, we got questions. Canton, Massachusetts. Dunkin's headquarters is in Canton, Massachusetts. Dunkin' Donuts started in Quincy and is in Canton, Massachusetts. I knew Dunkin' was a Massachusetts company. I just didn't know their headquarters is actually in Canton. I had no idea. They did. The very first one was in Quincy. But Spidey D might be the good PR that Canton needs. Because who knew? I didn't. I knew it was a Massachusetts company. When I saw that their headquarters was in Canton, I fell over. I was like, you've got to be kidding me. Why do all roads post back to Canton? Also, how many Dunkins are there in Canton? Because getting Dunkin' in Canton seemed to be a very central part of what was going on in the morning. I would also nominate Spidey D for DA. So there we go. It's a small world, isn't it? Canton. Their headquarters are in Canton. I had no idea. Well, the next time I'm in Massachusetts, I know exactly what I'm going to go do. Other than going to Stop and Shop, we're going to Canton to go to Dunkin'. I had no idea. So, Spidey D, I don't trust that the investigation into Spidey D's abduction is going to go well at this point because, well, it seems that you can kind of get away with whatever in Canton. And I imagine if anyone could pay off Canton PD in donuts, it would be Dunkin'. Because it seems that Spidey D is missing. Now, last year, I thought Spidey D was dead. At the end of the year, I thought Spidey D was a goner. But this year, Spidey D is 100% imprisoned. And Dunkin' admitted it. So, we need to go find out what the fuck happened to Spidey D. Because, y'all are like, Emily, it looks like you're sitting in the dark. Yeah, the outside changed. The outside changed because it's stormy. So I don't know if we're going to be able to figure out who abducted Spidey D. But it seemed that it seems that the Canton-based Dunkin' Donuts has admitted that they kidnapped Spidey D. Spidey D seems to be falsely imprisoned. Last year, I think he did fake his death. But it begs the question, would you fake your death to get out of Canton? I'm just asking. I don't know the answer to that. I don't know. Did he have help? I'm not sure. So let's go look at what Dunkin' posted when they admitted to falsely imprisoning Spidey D. Or maybe false imprisonment just isn't a crime. But it seems that Spidey D has been rehomed. Dunkin' captures Spidey in thirst trap, removes his login credentials. Okay, Dunkin', we're just gonna have to do this. Nope, wrong one. That one. Dunkin' captures Spidey in thirst trap, removes his login credentials. False imprisonment. I don't know. Pop-Tarts is distraught. Burger King said, I am starting a petition to free Spidey. KFC said, let him out of that damn cage now. Five Below said, as a fine shorty, it wasn't fun being used as bait. Get out of here, Five Below. But the thing is that there's video. Now, if Canton has video of Spidey D being thirst trapped, how are there no other videos? Because it seems that they were able to get video of this. Where are they holding Spidey? And why? What does Spidey D know? Why did they need to take his login credentials? Chat wants to know. Chat wants to know, was Spidey D in the group texts? Oh, the bottom is cut off. Dunkin's official statement. To our devoted followers. At 1:54 a.m. this morning, the menace known as Spidey D was captured by social media team in a thirst trap. Given his well-known love for, quote, daddies and, quote, baddies, it wasn't that hard to lure him in. After last year's hijinks, we decided to give Spidey D another chance this year. It's the longest-lived spider ever. Unfortunately, we are left regretting that decision after Spidey not only gave free coffee to everyone, all caps, he's telling them everything, but also made a series of unhinged posts that included suggestive comments about our mothers. We apologize for any inconvenience that this has caused the team at Dunkin'. Now, this was not posted in dyslexia font, but I can't help but noticing that a certain number of letters are quite bolded because it does seem that it says ILL RETURN. So all return, it seems, is within the Dunkin' message. But they have at least still images of security camera for the trap that they set. How do we have security footage? It's not even inverted. So how did they thirst trap Spidey D? This particular sign says goth baddies ahead. I agree, chat. There is no date or timestamp. Oh, wait, no, there's a timestamp at the bottom. The problem is that it's cut off on my screen, but at the very bottom, it does say 1:54:12. It does not have a date, though. There is a timestamp at the bottom. Non-inverted stills. Goth baddies ahead. Hot mom meeting. Fine shorties this way. 8 legs no limit. And then just blatant video of entrapment of Spidey D. A lot of you in the chat are like, not going to lie, goth baddies ahead. Would trap me too. I get it. I get it. So, Spidey D has been entrapped. They actually used the photo of Spidey D imprisoned in the thirst trap as the head image. Is there also going to be a book, Spidey D, Behind the Bars of Justice? Who leaked the video? How did the video get leaked? So Dunkin has entrapped Spidey D. Honestly, Spidey D didn't even make it to Halloween. Spidey D has not been seen on social media since. This was posted 5 days ago. And since then, the Dunkin social media has been quiet except for one post 8 hours ago. Emily, what did Dunkin post 8 hours ago? Swipe to shovel the snow off our holiday cups. Are you kidding me? We're not ready for snow. It's not even Halloween yet. What are we doing? They're just going to just skip Halloween and pretend it never happened? Also, are any of your holiday cups plastic? I mean, I know they come with a Dunkin bag, but how is Spidey D already gone? Also, what is with the need to have the holiday cups right now? And one of them is red or bright pink. I mean, it could be construed as solo cup-esque if you really, really tried hard. The fact that they're just going to pretend it's Halloween or Christmas and not Halloween is wild to me. But it seems that Dunkin is just going to pretend that everything's fine and we're all going back to normal. Canton's just like, we'll ignore it. It'll be fine. We'll ignore it. It'll be fine. I think this is why Spidey D ended up in prison. With the post that says, I hacked the app. Free coffee for everybody. There is a disclaimer at the bottom. But free coffee for everybody. Thank you, Spidey, for a free coffee since you're so thirsty is the post. So it seems that Spidey D released a code. Also, I love that Papa John's and I are on the same page. Papa John said the legal team just fainted. Yes, you've had a security breach with the spider. I don't know if you can still find Spidey D in stores. It seemed that Spidey D was also giving out lower back tattoos. The comment at the bottom of the post that says temporary tattoos free for my fans is dis, not this, dis, D-I-S, would, W-D, look so good on your lower backs. Because, of course, the tattoo says creepin' and caffeinated. It's really funny. Rachel said I was able to get one of the creepin' and caffeinated stickers. It's funny. So, Spidey D, does the breaking into the accounts, is that what landed Spidey D in custody? Or was it this? Because Spidey D did post, just got back from France, wearing what appear to be the crown jewels. I mean, they seem a little bit smaller. Then again, I don't know how big Spidey D is because, the internet, you can never really tell. Is he going to be extradited to France? That's my question. Is Spidey D going to get extradited to France? Spidey D also said got 8 legs, but still in group 7. The next post says, I'm not your pumpkin, but I sure am spicy. On the web and off my rocker. Don't go chasing water spouts, Spidey D. That looks very much like an in memoriam post. Pop-Tart said caught 8-handed. Look, Spidey D. It might have been the theft of the crown jewels. He might be getting extradited to France. I'm curious. Spidey D also shared his love for being a hater. And this one might be the most Canton-coded post on Dunkin's page ever. Because it's just Spidey D saying, I love messy group chats. I think Spidey D's in the group chat. You guys. I don't know. Maybe we're reaching. Maybe it's a little too true crimey. But what does Spidey D know? What does Spidey D know about the chats? Because though we don't speculate, we'll speculate about this case. We're going to try to solve it. Spidey D says, I love dancing on tables. You know what it doesn't say, though? It doesn't say if they are high top tables or not. So how do we really know? I do. I think Spidey D's a witness. Ooh, wait. Is Spidey D in witness protection? They had to smuggle him out of Canton? Because Spidey D's definitely going to tell on you. I love dancing on tables. It does not say high top tables. The next one says, I love gaslighting. I feel like our entire stream today is summarized in this slider post. Spidey D, do you know a lawyer named Ron Ron? Perhaps? I have questions. Spidey D says, I love rewatching my stories. I love blocking people. I love doom scrolling. I love spookiness, which I'm here for. I love 6'4" tatted, emotionally unavailable men. Damn it, Spidey. What are you doing? I love spiraling. I love biceps. I love triple texting. Spidey, stop it right now. I love being annoying or being annoying. And I love baddies. Are we still here? I love oversharing. Spidey, tell us about the group texts. The next one is I love confrontation. I don't get that from you. I love complaining. You do know Ron Ron then. I love romanticizing the bare minimum. Yes. Yes, we have a lawyer for you. I love rage baiting is at the end. I love not refilling the Brita. That it feels really personal. Who on the marketing team doesn't refill the Brita? Feels real personal. Feels real personal. So, Spidey D, my 17-year-old yesterday, I was talking about the food court for today, and he was like, what are you talking about? My teen does not spend much time on social media, especially not Instagram, which is apparently for the olds, or at least the older than hims. And so I was showing him these posts. I'm like, I have questions. And so your girl ain't afraid of spiders, but I still make her scream is not what I had on my bingo card for a donut marketing campaign. But in addition to that, if you ever find yourself going, what's funny on social media? The responses from the other brands are hilarious. Dunkin commented top of the morning. Pop-Tarts said, I lost my voice. Pop-Tarts has been so thirsty in these comments this year. Honestly, Pop-Tarts. Pop-Tarts is really trying to compete to be top breakfast treat. and the spider isn't doing it. But I don't know who A. Clark's life is, but 50 Shades of Glaze as a comment is fucking hilarious. Butterfinger commented and said, mind you, this is the first thing I saw when I opened my eyes. Original Funko said, Spidey, please, there's children around. Baskin Robbins responded, they all scream for ice cream, with the nail polishing emoji, which is really clever. Also, same company. So I feel like the Baskin Robbins is just the Dunkin alt account, and somebody's just logging out and logging back in. Papa John said, yeah, from fear. Papa John's, you've missed the joke, friend. That's not it. Elf Cosmetics said, Ayo fam, you good? Britta USA responded, are you trying to make me thirsty? Well, Britta, they're going to talk about you in a later post. Don't you worry about it. Don't you worry about it. So, I thought the Goblin post was going to be the most unhinged of the season. She ghosting you, but she gobbling me. I thought this would be the most unhinged post of the season. It's not. It's not. So, the most unhinged post, I think, of the season is the one that I take issue with. Spidey D, and the D stands for. Look, Spidey. We know that the D stands for Dunkin, first of all. Second of all, this has been a running joke with the Lawnards since at least 2020. You cannot come for the Emily D. Baker, what does the D stand for joke. It's our joke. Spidey, come on. What are we doing with the D stands for? The first one says, dang, baby, you look good. No. No. Spidey D, damn it. And the D stands for, sir, dongle. It stands for dongle, Spidey. Spidey D and the D stands for, dang, baby, you looking good. This got cut off because it's all the way at the bottom of the slider. But this one says, do you remember the 21st night of September? Nobody says the D stands for, do you remember the 21st night of September? Nobody says that. Nobody says that. No one says that. Spidey D and the D stands for debutante. Are you kidding me? That one's not even funny. Spidey D and the D stands for doctors hate my one simple trick. Look, if it's not going to be funny, can we leave the D out of it? Spidey D and the D stands for the mitochondria is the powerhouse of the cell. Seriously. Chad is saying D stands for death wish. It does. I think D definitely stands for death wish. As in Spidey D has a death wish coming for the D. However, Spidey D and the D obviously stands for Dunkin' Donut. Don't make me come for you, Spider. We might have to eat Spidey D on stream tomorrow. Don't make me eat you. Pop-Tarts, D as in dangerously handsome. The thirstiest brand in this fucking chat. Thirstier than Brita, Pop-Tarts. Thirstier than Brita. Cheez-It said, hi, baby, call me. Cheez-It, get out of here. Captain D Seafood. Finally, the D's are getting recognition. Look, maybe I should embrace it the way Captain D's is. Maybe I should be like, look, At least it's not D's nuts or D's donuts. That would have actually been pretty funny. Vivian in the chat said D stands for Don't Sue Me, Death Wish. D stands for D's Donuts. Jimmy Johns says, and the D stands for Don't ask what your spider can do for you. Ask what you can do for your Spidey. What are we doing, Jimmy Johns? And how long did we think about that for? Baskin Robbins said, I thought the D stands for Do you want a little sweet treat? That's funny. Home Goods says, tell a friend he's back or he's back. Spidey D. Spidey D and the D stands for step off of my bit, Spidey D. Stick to the thirst trapping. Also, another year of Spidey D trying to identity theft you. Spidey D says, trying to get to know you all better. What is your mother's maiden name and who was your childhood best friend? Don't answer those questions, everybody. We're going to do a teachable moment. Teachable moment. Don't tell them. Spidey D coming for the ID theft. D stands for your lawyer says don't fucking answer that question. Pop-Tarts. Again, you're such a silly goose. Duncan's comment on this post, by the way, is date of birth too. Date of birth. Mother's maiden name, childhood best friend. The next slide on this is not nocturnal, but I'll keep you up all night. So we've gone from identity theft to thirst trapping again. I didn't know that Spidey D could spin a web, but there we go. I borrowed your loofah. I don't even know how this makes sense. Because they're not asking the name of your childhood pet. They're really not. Wait, I was trying to pull this up. Darley in the chat said the D stands for Deaver's False Memories. Spidey D posts, I've got a phobia of haters. Edible Arrangements says, should I be concerned about slide number 5 or what? So I need to see what slide number 5 is. Which is Spidey D saying, I'm an edible derangement. I get it. I get it. I get it. Edible Arrangements is like, don't make us death wish you. No edible arrangements. Angel said the D is for damp dollars. I need a Spidey D damp dollars. Damp dollars. The edible derangement's actually really funny. It should have gotten its own post. The fact that Edible Arrangements not only found that and commented on it, it's really funny. Cheez-It said, give me my loofah back. Raid, the brand, said, nice try, Spidey. Now run. There are threats. They're not even threats in the DM. There's just threats. Walmart said, Mom, great value, childhood bestie, Sam's Club. That's actually kind of funny. Touche, Walmart, touche. That one's well played. Extremely one-sided beef, Ellie Mae. Extremely one-sided beef with Spidey. It's a sweet treat. But Raid is up here threatening people in the comment section. Didn't even DM it. Raid's just like, run. So Spidey D has taken over the Dunkin accounts, made merch, stole my bit, tried to sext everybody. And then apparently the group chat got leaked because this says do not swipe. My private pics are on the next slide. The next slide actually says caught you freak. Spidey D's got a new Spidey phone with the flash on, by the way. The Dunkin comment for this post was naughty, naughty. Pop-Tarts said, I still get to see that frosting. Pop-Tarts, what is happening? Every single post, Pop-Tarts. Every single post. Every single post, Pop-Tarts. Carl's Jr. says, is it such a crime to be a freak? Well, Carl's Jr., a lot of us do remember your Whopper Bacon Double Cheeseburger ads from the Super Bowl, so we're not going to comment on that. Papa John said, you knew I'd swipe, which is actually kind of funny. So, the Spidey D unhinged social media posting then released merch. Since you're so obsessed with me, I made merch. Tell your mom I said thanks for the vote, holding the best legs trophy. Is this the reference to the mothers that pissed off the Dunkin team so much? Is this what it is? Also, edible arrangements up in the comment section saying you gat, nice eyes spelled gat, like a junior high school student, G-Y-A-T, which unfortunately I actually know that is not the appropriate use for that word because I have a 13-year-old. Pop-Tarts responding, oh, so I got competition. Pop-Tarts, you don't have legs. What are you talking about? Every single post, Pop-Tarts. Dunkin posted, she's obsessed with me. Dunkin, unless your mom is Pop-Tarts, nobody can fight for the obsession because it's Pop-Tarts. Staples says Spidey got that donut riz for real with the emoji. Papa John says not her making it a family affair. God damn it, Papa John's. What is this? Best Buy says nobody stood a chance competing against you. I mean, Best Buy, it's actually literally true because 8 legs, I mean, you have definitely more chances of winning. Spidey D posted an invitation to a hayride. Welcome to my hayride. I said, hey, and you come ride. Duncan posted, everyone say good morning. First comment, Pop-Tarts, howdy. Butterfinger said, chill, my mom's on this app. Which is actually my teenager's complaint is that everyone's mom's on this app. Everyone's mom is on this app. Papa John said, all dressed up and no hay. I don't know why. Jeep is in the comments saying, we love a tops off ride. Jeep. I see what you're doing there. I see. It's well played. It's well played, Jeep. I'm not mad. It's funny. Baskin Robbins. It's too early for these shenanigans, Spidey D. The Philadelphia airport chimed in to say good morning. So then we get to trick or treat, smell my feet. When I make memes, you know it's heat. Papa John said, wait, you have feet now? Pop-Tarts, 100% unstoppable. Zillow said 10 out of 10 would trick or treat at Spidey's house. You'd get caught in Spidey's web, Zillow. You better watch out. So, Spidey D took the social media by storm, apparently took the crown jewels from France, proposed marriage to someone. Pop-Tarts accepted because Spidey D posts you can't spell spider donut without I do. And Pop-Tarts thirsty ass is in here saying, I do. I don't think they were offering to you, Pop-Tarts. I don't think this was a proposal. The next post simply says, 6'7". 6'7". The next post is Spidey saying, using my Wi-Fi to find me a wifey, holding the phone that says hot singles in your area. The next one is a DTL post. You up? Because I'm down. Spidey, what are we doing? Guess who? Lol, call me. You don't have to ask twice, Spidey. Pop-Tarts is jumping up and down for you to pay attention. Literally. And then Insomnia Cookies said, Spidey, you know we're up. At us next time. Which is actually really funny from Insomnia Cookies. Walmart says, I take thee to be my lawfully wedded spider. Funko says, you can't spell it without I don't either. Funko is popping into the comment section just to shade. What is happening? Funko. Stop it. So because we were trying to figure out how Spidey D got arrested, does Pop-Tarts actually have a tattoo? Wait, where's Pop-Tarts? You guys, what happened to Pop-Tarts? Temporary tattoos. Nothing from Pop-Tarts? I mean, Papa John says bold of you to assume it's not already there. But Pop-Tarts? Why did Pop-Tarts go silent? Was Pop-Tarts heard about the wedding proposal? When Spidey D got imprisoned, though, Pop-Tarts did comment, no. So, it seems that Spidey D has been arrested, placed in a thirst trap. I don't think Spidey D was given his rights. It's been 5 days. No arraignment. I think we have just a horrible breach of protocol. And I mean, I guess I shouldn't be surprised. But also, is Spidey D going to be extradited to France due to the apparent theft of the crown jewels? I guess we're going to have to wait because Dunkin's pretending like this whole thing never happened. Pretending like the whole thing never happened. Because now they're just like, time to talk about snow and cups. It's winter. Oh, Spidey D. All of you are like, is there even going to be a grand jury? I don't know. Where's Alessi when you need him? Alessi, free Spidey D. Free Spidey D. He's been kidnapped. Or spider napped. Or thirst trapped. I mean, he was also stealing my bit. But I think, the way of Captain D's, we can just be like, well, sometimes you just have to be inspired. We understand why Spidey D was inspired we got the purple inappropriate innuendos on social media. It's all fine. There's more in common. We can all get along. I guess all of us are a little tired of Pop-Tarts, who is just vying to be the most, I don't know, popular breakfast treat on the internet. So, Spidey D has been kidnapped in Canton, and I don't know what to do about it. Y'all, I don't know. There's nothing on the docket. They seem to at least have video, but I think the video is showing them entrapping Spidey D. Then again, they're not a government agency, but we don't know. Was Canton police pretending to be Dunkin to trap Spidey D? Because Spidey D seems to be in the group chat. Who else is in the group chat? Canton? We have questions. Lots and lots of questions. So for all of you who have enjoyed Food Court, A, it has been 5 hours of Food Court. And B, well, we did have to talk about Ron Ron. And B, tomorrow afternoon, we will be back in Canton. I am going to be running late. Tomorrow, we will be back in Canton. If you do not have the Lawnard app, now is the time to get the Lawnard app. Tomorrow we are going to court. There is a hearing in the Miles King et al. Cases regarding Proctor's phone discovery. So tomorrow we are going to go back to court. I might have to go track down Spidey D. Maybe he's hiding at my local Dunkin. And see if I can go find Spidey D before court tomorrow, because we need to bring spider snacks. Or at least some munchkins. I mean, what are the other? But we are flying back to Massachusetts. Maybe, who knows? Maybe we'll find Spidey D in court. But we are flying back to Massachusetts tomorrow for court to see what is going on with Spidey D. I always love food court. You guys are the best. I am A, always amused. B, it has been a very long stream today. So my brain is like, after lots of streaming, my brain is like, we are tired. And tomorrow we're going to have to zoom through court, because then it is family time. We are coming up on spooky season. Well, we are in spooky season. We're coming up on Halloween, which is a lot of fun. Mildred Caddy said Dunkin' number 1 is in Quincy, Mass. Headquarters is now in Canton. It does seem they moved from Quincy to Canton. I had no idea. Hunk Banana No in the chat said my safe word is Boston cream. We'll have to ask Spidey, but I feel like maybe Spidey knows all. Becca has thoughts, said Spidey knows all. Free Spidey. Did Spidey get hidden? Spidey D gave me a year of free coffee. That's amazing. That's incredible. Congratulations. Maybe this is why they locked Spidey D out of the accounts. But I have to think it has something to do with the Pop-Tarts. Right? Daniel said, if you've never air fried an Uncrustable and put cinnamon sugar on top of it, I highly recommend it. I'm not going to tell you where to get the Uncrustable from, because food court. Cinna, yes, I did get a garlic scented book. We're going to talk about it on members only. Don't worry. Orbiter said, abandon all hope, ye who infringe on death. It's fair. It's fair for everyone who super chatted. I know we didn't get to all of them. I am so sorry we did not get to everything. We absolutely talked so much, because we had all of the things. I know some of you had some YouTube troubles today. I apologize. It has been, I wonder what they're updating, because it's been a bit of a problem. Music to My Soul said, true or false, Chili's brought back their queso to avoid a food court lawsuit from EDB. I mean, I really definitely wanted them to bring it back. I just, like last weekend, it wasn't there. I'm sure the customer base was like, we literally showed up for the queso. What are you doing? Skillet queso, please. Sunsea in the chat said, Emily, I passed the bar exam. Woohoo! Congratulations. 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 I hope it is a massive relief. Well deserved. I'm sure the chat has celebrated. I think today we got to numerous code breads, unhinged behavior, at least one Spidey D food fight, unhinged lawyers. And now Fred has come to remind me that I am supposed to be done streaming. Hello, Fred. We have summoned the cat. Lawnards, you are the best. Mildred said, I spy the Spidey D. I did capture a Spidey D bucket. I was very excited about it. I did not capture a Spidey D keychain. We'll see about next year. Oh, you guys, I will have to see if I find a link to the earrings to share it, because I do not know if they're available outside of where I got them. And I know they're sold out where I got them. So I will see if I can find a link to put in the Amazon shop, because these exact ones are sold out. I'll see if I can find them on Amazon from the same company, or a similar pair from the same company, and I will link them. So no worries about that. I will probably also wear them tomorrow, because they're so much fun. Hi, Fred. Yes, I see you. Fred is now just, catting at me. You cannot chew on my ankle to get my attention. Actually, you can. He's like, yes, I can. I have to say goodbye to the Lawnards. In 30 seconds, Fred. Fred is trying to manage the mischief and create all of the mischief. Fred says goodbye to the Lawnards, and he says, if I do not get attention now, it is going to be a problem. Lawnards, you are the best. We will be in court tomorrow. So, court is in the afternoon. So I think they are scheduled for 2 p.m. Eastern. So we will be live around 1 p.m. Central. I will probably go live a little earlier because then we can talk about Alan Jackson ripping into Boston PD, because that's exactly what we are going to do tomorrow. So Lawnards will be in court tomorrow. Yes, Fred. Yes, I see you, buddy. Lawnards, we will be in court tomorrow. Don't forget to get the Lawnard app at lawnardapp.com. I will see you soon. Okay, Fred, yes. My cat has said it is time. It is time. So we're going to go see what Fred wants. I'll see you guys soon. Bye. Fred, now the outro won't play. You have fuckeried all the fuckery, cat. One more time, and we'll see if it'll play now. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnard.